May it please your lordships. My lord, item number 17, my lord, 17. We have taken consent of the petitioner, my lord. It may be taken up on some other day, my lord. 17. 17, my lord. They have given consent, my lord. After 2 weeks, a date may be fixed, my lord. After 2 weeks, a date may be fixed. My lord, I have another prayer, my lord. Item 28, my lord, bail hearing. I have inquired, my lord, case up to date case diary was called for. It has not been received, my lord.
Not received, lordship, and they are all already on interim, lordship.
Which one? Item number
28, my lord. Bail hearing.
28. AB.
AB. 7th of June.
7. You are on interim.
I am on interim.
7th of June.
Obliged.
May I please, my lord, I beg to mention for listing, my lord, bail application, my lord. Another similar matter is, my lord, CD was called for, my lord, which is picked on 13th, my lord.
Lordship, item 51, Lordship. We need some accommodation till 28th of this month, Lordship.
Till 20?
28th, Lordship.
So you are for it?
I am for the respondent number 2.
I am for the petitioner, your lord.
They need up to 28.
Yes, we have no problem, my lord. But there is an interim order. Let it continue till then.
On 28 or it will come after 28?
On 28th.
You want 28?
20th.
20 is the very
Tuesday. Hearing method, Lordship. Hearing. Deeply applied.
May I please your
interim was
lordship.
there, na?
Yes, my lord. Interim.
Interim.
May I please your lordship. I actually mentioned item 45.
Right.
Lord. Kindly possible to meet up for the day, Lord.
The CD is available, 45.
Well, here
Yes,
case,
CD is available.
yes, my lord, case there is available.
Only for the day, Lord. I have some personal difficulties, Lord.
You have some person.
Lordship.
It can be written till it says lots of matters during this Monday can make this Monday. No, not because CD is in. List is also out. Either 13 or 14 can be accommodated. Till then you have to retain the deadline.
Tuesday. My lord, 40.
Number 45.
45,
But
yes.
we are listing on 14. So CD is asked. So we are going to retain it.
Lordship. Deeply obliged, Lord.
May it please your lordship. Lordship, I have filed additional affidavit in connection with item number 10, lordship. That may be called.
Act number 10.
10. Hello.
May I please your lordship? Lordship, I beg to mention item number 46 of the daily list, lordship. In this matter, lordship may not like to take up this matter, lordship. Perhaps lordship
May not like.
take up this matter, lordship. Lordship has perhaps no
Item 46.
46.
Adjournment.
No, lordship may not like to take up this matter, lordship.
Why?
Lordship has no perhaps lordship.
Chalo.
Any order passed by
No, lordship. Interim order passed by Honorable Justice P.C. Speaker, lord.
My lord, how it can be, my
No, lord.
yesterday only, my lord, similar case has been heard by your lordship.
No, lordship perhaps knows the client, lord.
I know the client. Who is he?
You know, one Raju Medak, my lord.
No, Bikram Singh.
Bikram Singh Locker. 46. 46 to question.
I know. the
46 already adjourned, my lord.
No, 45.
45. I think.
Oh, 45, yes. 46. Here also, my lord, case diary received, my lord.
I cannot recollect his name, who is he, or if I can know him, if I know him. But as he said that I know him, that better not take. But I don't know who is he. Vikram Singh
No.
Rothward.
No.
Actually, I don't know. It
Then,
has
my lord,
not
wow.
been
If lordship may don't know, recollect his name, my lord, how can he say it, my lord? The lordship. Then, my lord, in every cases, my lord, the council may come before this honorable court that bench hunting is there, my lord, nowadays. That's why, my lord, very dangerous.
No,
my
no,
lord.
no.
Oh,
Nowadays, very
No, no.
dangerous, my lord. This
No,
kind
lordship.
of, my lord, things was happening in this court, my lord.
No.
but I'm personally.
In this case, my lord, the interim order has been got by the
Who is
petitioners,
Vikram
my lord.
Singh Rothward?
No,
Because
Lordship
I
may,
don't have any
Lordship may
connection with
fix
Kalupari.
it on the same day, Lordship. Today also, Lordship can fix this matter, Lordship.
Today already matter is
We-
fixed, my lord.
we are-
Case diary
we are
received
ready.
in this case, my lord.
Your sufficient letter, I know the person.
Yes, Lord.
From where you have come to know,
Yes.
I know the person.
Lordship, as per the client, information of the client.
Information of the client. It says, but I don't know. In fact, I don't know.
Then Lord-
Really. Who is Vikram Singh Rothward?
Then, Lordship.
But you have, if you have some such kind of thing, then I won't take. Because if client says that he knows me, but I don't know him.
My lord, then every client has known the judges, my lord. He say, well, I know such and such judge, my lord.
Otherwise, Lordship, we have no issue to do the case, Lord.
But as per your client information, he
Lord.
said that I
Lord.
this bank should not take.
Lord.
Such kind of information is with him, then I better to have. I don't know why, who is
Lordship may
that-
fix it on today also, Lordship. We can, before the any other bench, Lordship may fix.
How can I say? Personally, I just don't know who he is. Because with Jalukpadi, I have very little connection with Jalukpadi. Other, I don't have any connection with Jalukpadi people.
Here matter is very sensitive, my lord. This is a corruption case and CM vigilance case,
No.
my lord. And case that we have received, my lord. On the last occasion, it was mentioned before the court, my lord, as an unlisted motion. Production list has been kept. They have got interim. Matter was fixed today for my
Because,
lord.
Lordship, as per the false information, Lordship,
Interim was there, na?
My lord, yes.
For us to take if I know the person or the person knows me, I don't know. Who is taking the other bench? Is it criminal bench?
18 and 15 is there, my lord. So 18 is my lord. 18 is my lord special bench. List before the court number 15, my lord.
otherwise, Lordship matter is IPC, Lordship. Lordship may fix it on today also, Lord. We have no,
Really, talking about today. For saying that I know the person.
Lord.
I don't know the person. No, who is from I have no, I don't know at
Then,
all.
my lord, where is the bar your lordship may taken up the matter?
I don't know. He is saying that the client know me. I don't know.
My lord, that's why I'm saying, my lord,
That is one.
every councils may come say that lordship, my client knows lordship, then may not be taken up the matter, my lord.
You know, I have gone and contacted one.
Yes,
But
yes.
I don't know personally. Right?
Special bench is court number 18, and lordship may send the matter for because there is no any special section is there. So let it be sent to the court number 15, madam. There are 3 criminal benches now, court number 15, 18, and 22, madam. Done. Lord. My lord.
don't know him.
My lord, the date, my lord, then today or my lord,
Today, Lordship.
Monday. Monday, my lord. Case is very unjust, my lord.
Lordship in the matter may be continued. No,
Lordship may
Lordship.
take it up the
Otherwise,
matter. How
Lordship,
can Lordship may pass the order, my lord?
then Lordship may fix it on today, Lordship. No, Lordship. Otherwise, Lordship, he will take.
Much obliged.
Lordship may today, Lordship. Lordship may direct the registry also, Lordship. And Lordship can take up this matter. Otherwise, Lordship, it is very difficult, Lordship.
After passing the order today,
Deeply.
May it pleases your Lordship.
today I will because I don't know him. There were some
May it pleases your Lordship. I beg to mention for listing of an anticipatory bail application, Lordship, on Monday. Monday.
Motion.
but it's
Motion.
but it's
Oh, okay.
May I please your Lordship? I beg to mention item number 39 and 42, Lordship.
39, 42. Both the cases, Lordship, case diary not received.
42, Lordship. Lordship. Interim, Lordship. After 2 weeks, Lord.
39, CD not received, Lordship. And they are on in time, Lordship. Ten six, Lordship.
May I please, Lordship? I beg to mention item number 26, Lordship. Item may have done for the day, Lordship. I have serious not received.
CD not received, Lordship. 26.
26.
Intimation A.
BA.
BA. Then Vishwanath, Lordship. Can it be on, Lordship, 16 or 17, Lordship?
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 29, my lord. In this case, my lord, subsequent 2 more sections were added, my lord, under POCSO and 76. At present,
Yes, Lordship. Now, Lordship, section 6 of POCSO has been added. So this will have to be transferred to the special bench. Yes, yes. And the matter will have to be taken up by the special bench, perhaps.
and I may be allowed to file IA, my lord, to insert this subsequent section in clause title.
Because Lordship, when the case was registered, it was not registered under special act. Subsequently, yes. So Lordship, they will have to correct and file affidavit. In the meantime, the case diary has been received by us, Lordship. So this matter can be taken up by the special bench, Lordship. Because as per the roster, special bench is there. Code 18. Code
29.
18, Lordship. 18.
but
Yes, Lordship, that is there. They will have to first correct the cost title and everything. No, Lordship, they will have to file IA, Lordship.
I am, my lord.
They will have to file IA.
J. Ahmed.
Yes. But they will retain the CD, Lordship.
Could you retain? Published.
May I please, Lordship? Lordship, I beg to mention item number 40. Metro 40, Lordship. Metro may be adjourned to the day.
CD has been received, Lordship.
Lordship, actually, my senior is out of station. Therefore, any day on the next. No, Lordship. I think on next week, Lordship.
Lordship. Lordship. Retain. Next week.
Okay, 14. Published.
Sorry, my lord. Item, in respect of item number 29, my lord, we are on interim, my lord. Accept the accused number 1, my lord. 2, 3 and 4.
2, 3
Total
and 4.
2, 3 and 4 on interim.
Yes.
Let me go. Published.
May I please, Lordship? This is a 439 application. Today is 54 days and FIR is on page 13, Annexure 1. So, Lordship, here, where perusal of the FIR, nowhere it is evident that the attempt to murder Gravias Hard was wrongly inserted by the police. And from the FIR, may I read the FIR, Lordship? With due respect, I would like to inform you that on so and so at about 1 p.m. 1 p.m. as per the search warrant issued by the Court of Appeal, Anis Rasul Majumdar SS additional distinction so and so under section 94 charges I along with WPC Moyuri Miti and 50 ABPH staff and also accompanied by first party Munima Begum, daughter of Manik Ahmed, wife of Dulaluddin, went to the house of Dulaluddin, son of Abdul Jabbar, resident of Ujandihi, to recover the marriage articles, and we started everything. And we stated everything about search warrant to them and started search as per the guidance of wife and recovered the articles from the house of husband. But during the search, below mentioned accused person jointly as pre-planned manner with the lathi and shuffle attacked the first party wife and her family with dire consequences. When we want to stop them, they also started using force to police staff and also create obstacles in doing our duty. They also beaten severely our department and divert so and so. They also torn the uniform and pushed WPC Moyuri Miti and he fall in the floor. They also damaged the article of wife and stole some other articles. Apart from them, they also damaged the front side of the departmental vehicle with shuffle and they injured 4 persons from the wife's family. So there is no FIR from the wife's family. At the search warrant, the police intentionally helped the wife's family to recover the articles, and when we protest them, there is a scuffle. And police colored the whole matter and inserted so many sections of the IPC. Today is 54 days. They are in custody from last 18/3/24.
Of course, my lord, police helped the family of the wife of the family of the wife, because my lord, police went there for execution of the search warrant and for recovery of the street honor articles. And thereafter, my lord, when police went there, these accused persons, my lord, in a group attacked the police personnel, torn their uniforms, and also, my lord, damaged their police vehicle, my lord. All these allegations for which, my lord, there are lots of section, my lord, in this FIR against all these accused persons, my lord. Total 4 police personnel injured, my lord.
But your lordship, no FIR from the wife's family.
Oh, yes, my lord, because my lord, offense, they have committed the offense against the police. I'll get the case diary, my lord.
already some there was there. Today is the 54 days. So during the actually everything.
307 was there.
Yes, my lord. 353, 333, my lord.
All the section inserted. All the section, the 307 day.
And all the accused persons, they attack all the police personnel in a group, my lord.
No. They are stating that at a group the wife family. When they protest
Definitely,
them,
police will help the wife family because police, when they are for execution of the third
Certainly. Recovery of those hidden items.
Yes,
So in that process, people came in a group, calls hard not only to the family members of the wife of the person, but also the police person. That's it.
yes.
I don't know 307 or there may be that it may not be there. But obviously from the plain reading of region, they
307 is wrongly.
maybe may not be, but 330.
I will try to get it on my 17th of May.
Problem.
May be before Lordship. My Lord, particular bail application, my Lord. Lordship will find a FIR, my Lord, page 12. My Lord, allegation was that, my Lord, on 15/4/24, my Lord, the police has received an information that some persons were involved in gambling. So, upon receive the information, they proceed to the spot, my Lord, where gambling was going on, my Lord. And taking the advantage of the darkness, those persons who were involved in gambling flee away. So, my Lord, on that day, there was a boja was going on. So, my Lord, they have, my Lord, informed the members of the Charak Boja committee, my Lord, that one boja was going on in that locality, that to inform those persons who were involved in gambling not to further involve again. So, meaning thereby to stop the gambling. So, while returning, this accident happened that one, the Bash Tas, my Lord, he have invited many other persons, my Lord, those local people, and started, my Lord, fighting with this police personnel, my Lord. And that police, one of the police personnel, the present informant got injured, my Lord. Now, here, why the reason I am arrested is, my Lord, kindly see next page, my Lord. I am the president, my Lord. The president and secretary, however, were not present at that time. This, my Lord, it reveals that, my Lord, this person, my Lord, the present petitioner is the president of that committee, my Lord, where boja was organized, my Lord. So on that pretext, my Lord, on suspicion that I was apprehended, my Lord, otherwise, my Lord, FIR, if we go by the FIR also, my Lord, I was even not present, my Lord, at that point of time, my Lord. And, my Lord, this section, my Lord, these all sections, my Lord, 333, my Lord, that is, my Lord, 333 regarding the voluntary causing grievous harm to deter public servant from discharge of his duty, my Lord.
FIR in original? Original FIR is
Original FIR, my Lord, can you see the page, my Lord? Is, my Lord, Asmi's, page 19, my Lord. Asmi's version, my Lord.
Not at all legible.
not legible.
Not legible.
See one thing. Where is the bowl in the translation copy?
Yes.
There is a bowl that the president and secretary, however, were not present. Is there any such kind of sentence?
My Lord, here in the translated copy also specifically stated that how those illegal activities were going on only because of the, my Lord, the president and secretary of the Puja committee allowed playing gambling by taking money. So thereafter, my Lord, when police, my Lord, went to that place, my Lord, the accused person attacked the police personnel also.
So it's okay. But
they may not be present there because from the, my Lord, contents of the FIR, it seems that it is because of the, my Lord, those illegal activities were going on.
The sentence can, whether there is any sentence. Yes, these two president and secretaries were not present.
Yes, my Lord.
Somewhere it is there, my Lord. Although I am not well versed, my Lord.
This one, Joan Koho, জাননীৰ চলি থকা সড়ক পূজাথলীত কিছুমান লোকে জুৱা খেলি থকা বুলি সংবাদ পাই আমি জাননীলৈ যাওঁ। যোৱা সময়ত আমাক মাননীয় অস্থি আমাক অৱগত কৰাৰ জুৱা খেলি থকা এজনৰ অসুবিধা আঁতৰিছে। Here in the FIR, it is not specifically mentioned that at that point of time whether President and Secretary were present there or not. Only specific allegation is that.
No, because it is in bold letter, it is there that President and Secretary were not there.
Yeah, পূজা কমিটিৰ সভাপতি আৰু সম্পাদকে টকা লৈ জুৱা খেল বহুৱাইছিল বুলি জানিব পৰা যায়। That is the only the allegation.
But whether their presence is
Regarding their presence, that is not mentioned in the FIR.
তেওঁলোক সেই সময়ত তাতে উপস্থিত নাছিল।
উক্ত সময়ত সভাপতি সম্পাদক আঁতৰি থাকে। গতিকে অনলি মাইলৰ এট ডেট পইণ্ট অফ টাইম দে ৱেৰ নট উক্ত সময়ত সভাপতি সম্পাদক আঁতৰি থাকে বিকজ এট ডেট পইণ্ট অফ টাইম ৱেন ডেট ইনচিডেণ্ট ৱাজ গয়িং অন কমিটেড বাই দি আদাৰ পাৰ্চন প্ৰেচিডেণ্ট ছেক্ৰেটাৰী মে বি প্ৰেজেণ্ট দেয়াৰ বাট দে আৰ নট ডাইৰেক্টলি ইনভলভ মাইলৰ।
No. First part, my lord.
Why I ask you it? Because state certificate is there.
Yes,
whether the involvement in state certificate is there or not. That's what.
Now,
otherwise let them appear.
See, my lord.
Because my lord BA, my lord, the problem is
they are only when there is
first part says, my lord. First part of FIR also, my lord. That may be relevant.
16/4/24. 16/4.
After, my lord, when they proceed to the occurrence, reach the plan, since they
because the allegation of by allowing camping in the Puja, Puja campus, that is there.
Yeah.
But while police was there any?
Otherwise, my lord, while that puja, my lord, celebration was going on, it is the duty of the president and secretary that such type of activities.
But they are allowing.
My lord, one thing.
That means they are supporting those illegal activities.
My lord, one thing. First part of the FIR says that since the accused those persons involved in gambling flee away, they inform the members of the committee. That is very clear, my lord. Which conjoint rating, my lord, of the FIR, my lord.
16/4/24, they were in this. Your lordship, otherwise I will leave it to your lordship.
And my lord, injury part is there, my lord. Page 23, my lord. Page 23. Simple injury.
Here was arrested on
16/4/24. 25 days.
and continuing back there. Okay, you will be paid.
My lord,
Your country will pay.
I am obliged, my lord. Condition, my lord.
Karpi Anglo? Oh, no, no.
My lord, CGM, my lord.
CTM? Dipu, Karpi Anglo?
Yes, Karbi Anglong Dipu, my lord. Bail rejection was passed by otherwise additional CGM, my lord.
Dipu, Karpi.
I am obliged, my lord. Condition 2.
Wait, please, your lordship. Lordship, FIR is page number 7.
Page number
7. Yes, lord.
Yes.
Most respectfully, it is submitted that on the night of 8/4/2024 at about 8:30 p.m. the motorcycle bearing registration number AS01FD 1028 Royal Enfield registered in the name of my wife was stolen from Sonapur Notun Bazar. Thereafter today, after coming to the police station, I came to know that the police personnel of Sonapur police station had in the meantime recovered my stolen motorcycle and arrested the aforesaid accused persons, the thieves, and brought them to the police station. Since I was searching the stolen motorcycle, there has been delay in lodging the SIR. It is known that the aforesaid accused persons since long are involved in stealing motorcycle and selling the same. And the description of the stolen motorcycle is motorcycle registration number AS01FD1028 Royal Enfield 350cc, chassis number so and so, your lordship. And the seizure list is page number 15. The seizure list is page number 15, lordship. Description of the articles: 1 Royal Enfield, non chassis number so and so, Deputy Nat, Sonapur PS, 66 of 2024 under section 379 of IPC. Your lordship, already stolen article is recovered. And your lordship, the particular of the FIR is, your lordship, page number page number 13. Yes, lordship. Oh, here mention, your lordship, incident has been committed on 8/4/24 and the FIR lodged by the informant is 10/4/24.
And it not got arrested.
Shown arrested, ma'am.
Shown it.
Yes.
They were in other.
Yes, ma'am. Additional offender, ma'am.
In a same police station.
Yes.
Is there be call for is there? Because
Already
there is
articles are recovered. Articles recovered. For which?
Articles recovery is the one part, but the question is there the habitual offender. Because they were shown arrested on it as he was.
And the page number 17.
Arrested in other.
Lordship, and the page number 17. Here under section register 379 and 41. Yes.
Okay. 430.
21/5 months.
Much obliged.
May I please, your lordship? Lordship, I intend to withdraw this petition. Lordship, my name is K. Thakur, lordship, on behalf of D. Medhi, lordship.
Yes, I was searching for the name.
Lordship.
Appearing on top of it.
D. Medhi, lordship.
Okay,
I level it.
May please, your lordship. Lordship, 410 bail application, lordship. The petitioner was arrested on 12/3/2024. Today, 60 days in custody, lordship. And lordship, the allegation pertains to alleged recovery of lordship fake gold and fake currency, lordship. And lordship will find the FIR at page number 13. It is lodged by one lordship police officer, IC of Bongamora Outpost. Page 13, lordship. May I read, lordship? This is to inform you that one secret information has been received that some people at Ahmedpur and Islampur area prepared to dealing fake gold and fake currency to cheat people of Arunachal, Guwahati and Nagaon. In this regard, one GD entry is made by Bangalmara OP GD entry number so and so. Accordingly, I along with Deputy SP Headquarters Lakhimpur OC Bipuria PS with staff searched the house of one Bilal Hussain. Bilal Hussain has been released on bail by the Honorable Court. Son of so and seized 3 numbers of mobile lenses suspected fake Indian currency note rupees of 1,12,000, Indian currency of 4 lakh, and apprehend the accused person. Another has charged the house of Kurban Ali. Kurban Ali has also been released on bail by the Honorable Court. Son of so and seized 1 mobile handset, 1 golden color board, fake Indian currency note rupees 1 lakh, and apprehend the accused person. Again searched the house of Anarul Islam, son of so and seized 1 golden color board, but the accused person was not found at his home. After interrogation, the above accused, it came to know that they prepared some fake gold and fake currency note with intent to cheating some people of Arunachal Pradesh, Guwahati and Nagaon. This is the FIR, Lordship. And Lordship, allegedly from his house, Lordship, 38,000 Lordship fake Indian currency was recovered, Lordship. Lordship will find it page number 26 as seizure list, Lordship. 38,000 from his house. And thereafter, Lordship, 4 of the co-accused persons have been granted bail by this Honorable Court. Lordship will find the order, Lordship, from page 28, Annexure 4. This Bilal Hussain and Kurban Ali, they were released on bail after 35 days in custody. Page 28. Then Lordship, page 32, Khairul Islam. He was released on bail after 32 days in custody. And thereafter, Lordship, page number 36, another Lordship, Baharul Islam, alias Ambani. He was released on bail after Lordship, 14 days in custody, Lordship. So, Lordship, the fact is that he is behind the bar for 60 days, Lordship, and everything has been recovered. So, Lordship, on the ground of parity also and length of detention, Lordship, I am allowed to go on bail, Lordship. And Lordship will find that on the basis of statement of co-accused, he was arrested. And from his custody, from his house, Lordship, that amount was recovered. 60 days, Lordship, he was thoroughly interrogated, Lordship. Articles have been seized and recovered, Lordship. And length of detention, Lordship. Ground of parity also is there. And no victim has, Lordship, lost the FIR. One police officer, that IO of that, Lordship, IC of that outpost, Lordship. And till the time they were granted bail, Lordship, no victim could be identified by the Lordship IO. That is, Lordship, reflected in the order, Lordship. Any Lordship,
these are economic offences, my lord. Parity cannot be a ground, my lord, in this type of cases. Otherwise, my lord, length of detention, your Lordship has earlier produced the case diary regarding other accused persons, my lord. Although, my lord, he is playing on the ground of length of detention, my lord, in this type of cases, length of detention is also not a ground, my lord. These are economic offences. In all these cases, earlier cases, your Lordship, after perusing the case diary, your Lordship has granted bail.
But Lordship, I am on similar footing, Lordship, that amount was recovered, I am not denying it.
Similar footing will
but
not
489B, if 489B is not coming, Lordship, then the statutory period is 60 days, Lordship. For 489B, Lordship, he has to receive from somebody, or he has to give somebody, Lordship. Till that point of time, Lordship, no victim could be identified by the IO, Lordship. It was in the case diary, Lordship. It was in the order also, Lordship. Lordship has observed that, Lordship. So, Lordship, on the ground of that, Lordship, parity, Lordship, can be, Lordship, ground. And page 17, Lordship, specifically in the forwarding report, accused person Khairul Islam stated that the Tomial is directly involved with them, Lordship. Khairul Islam, Lordship, has been already granted released on bail, Lordship. 60 days, Lordship, he has been thoroughly interrogated. IO has got ample opportunity to interrogate him, Lordship.
58 days.
60 days. 12. Articles have been seized and recovered, Lordship.
Night. Please, Your Lordship. Lordship, here petition number 1, 2, 3 and 4 was arrested on 3rd April, Your Lordship. Total custody 37 days, Your Lordship. And petition number 5 and 6, Your Lordship, 35 and 34 days, Your Lordship. Petition number 1 is suffering illness, Your Lordship. Petition number 5 is physical handicap, Your Lordship. Here, almost all the accused persons are on interim bail, Your Lordship. I have annexed that order, Your Lordship, annexure G to annexure K, Your Lordship. Your Lordship also ordered there, Your Lordship, on 6th May, Your Lordship. And another FIR accused person already released on absolute bail, Your Lordship, as per order dated 23rd April by Learned Court, Your Lordship. Annexure L, Your Lordship, page number 41, Your Lordship.
All are interim bail.
Other interim bail, Your Lordship, we are custody, Your Lordship, 37 days, Your Lordship. And we consider the custody and detention.
They are also interim bail.
No. We are in custody, Your Lordship.
Other accused person.
Other are interim, Your Lordship. Only this custody, Your Lordship. Custodial period may kindly consider, Your Lordship, 37 days in custody. L is section, Your Lordship, 120B, 147, 148, 353, 325 and 307, Your Lordship. 307 not attracted, Your Lordship, others are simple. Injury is 325, Your Lordship. 37, all are local personnel, Your Lordship, some villager, Your Lordship. We are not involved in the incident. The incident took place nearest to our home, Your Lordship. We try to maintain the peace, Your Lordship, in the locality, Your Lordship. Kindly custody period may kindly consider, Your Lordship. All are not professional criminal, Your Lordship. Simple villager, Your Lordship, and a small businessman. Petition number 5 is physical handicap. I mean, next their documents. One are suffering illness.
Well, this type of incident continuously going on. While police personnel went to perform their duties, these persons in a group, in a pre-planned manner, they attack those police personnel. Not only today, this is third case.
Actually, we are not involved with the 37 days in custody, Your Lordship. There is a negligence from some duty of police, Your Lordship. Some people maybe let quarrel, Your Lordship, in that place, Your Lordship. But we are not involved, Your Lordship. At least 325 and 307 not attracted at all. And 147, 148, 353 and 120, Your Lordship. 37 days in custody, all are simple person, Your Lordship, simple villager. No any other criminal record, Your Lordship. And step period may kindly consider.
Others are very.
Yes. Only on the ground of length of people.
They have rightly pointed out all for police, the other party, the type of person. They in a group they came and then
Yes. In a pre-planned manner, this type of conspiracy is going on against the police personnel.
Arcari में
not but they're not pardon, it not active. And fourth, there be that's 35 days. How many days there be antibiotic?
37 days, petition number 1 to 4. And 5 is 35 days and 6 is 34 days.
And petition number 1 to 4.
1 to 4 are 37 days in custody.
Number 5.
35 days. 35 days.
Person of the already it has already and petition number 6 is
34 days.
is Bodipur petition means Kamru.
No, no, CGM Dubri. Dubri. Oblige.
Lordship, item 53 is connected to item number 25. In 25, Lordship, CD was called for that has been received, Lordship. So both the matters can be heard together, Lordship, at a time of 25, Lordship.
Item number 53 is with
Connected with item number 25. It's bail hearing, Lordship.
Yes.
CD is there, Lordship. Arising out of the same affair.
Yes.
At a time of 25, Lordship. Oblige.
May I please, Lord? My Lord, this is under challenging the order passed under 125 of the CRPC for reducing of the maintenance. So, my Lord, in the IA, my Lord, the legal aid counsel, Mr. P. Sekia, was appointed. So, his name, I think, no, is not shown in the POSNIS, my Lord.
in IA.
In IA, my Lord. P. Sekia was there.
While disposing at the time of getting
Your Lordship's order was there. So it will be, my Lord, his name may be reflected.
Have an information whether he is appearing in this case or not.
It is your Lordship has appointed him as a legal aid.
Yes, he was there.
Yes.
Now,
Once he has accepted the brief, his name is shown, let him come and say. Or your Lordship may admit it in the admission stage. His name may be shown and the record may be called for.
let us see
On my.
The cases, the registered number, as in further to order it. 2014 IA Tribunal 11. It seems that at the time of hearing of it was the budget council for the one, but the Mr. P.
problem. बोला.
My lord, this revision petition is filed by the state, my lord, enforcement directorate, my lord. My lord, the impugned order is in page number 35, passed by the learned special PLMA judge, my lord. My lord, here my lord will come to page number 35. The brief, I'm just giving a brief, my lord, regarding the order, my lord. My lord, this is initially we filed in section 8(7), my lord, application before the PLM special court, my lord, for consideration of an flat of the accused, my lord. So, my lord, basically, just I'm reading from the order, my lord, para 2. The Director of Enforcement, Guwahati Zone Office, by filing an application under section 8(7) of PLM Act 2002 prayed this court to confiscate the immovable property, flat number such and such, my lord. So, my lord, what happened during the brief of the thing is that, my lord, we filed complaint, that is our charge sheet in 2018. Just after that, the accused passed away, my lord. The accused died. So, my lord, will come to page number 39 of the order, my lord, this of the petition. The second paragraph, this is what the Honorable Court held, my lord, the learned court below. Page number 39, second para, my lord. The ultimate object of the criminal proceeding is to punish the accused of his conviction of any offence. Therefore, the criminal proceeding abate on the death of the accused, as their continuance thereafter will be infructuous and meaningless. In the case at hand, due to the death of the accused Jaydev Das, the case was abated before consideration of the charge against him. So, well, basically, the learned court below has held that since the accused has died, passed away during this continuance of this trial, my lord, so now it is infructuous, my lord. But, my lord, now I mean coming to what the learned court below could not appreciate, my lord, the PLMA Act. My lord, I'm just taking, my lord, to page number 9 of the petition, page number 9. Page number 9, my lord. My lord will, my 3.5, my lord. Here, my lord will find that apartment, my lord, under 5(1) PLMA Act, we moved an application before the adjudicating authority in Delhi. The adjudicating authority has confirmed it. Thereafter, my lord, the accused, the deceased accused now, my lord, he moved an application before the appellate tribunal, challenging the order of the adjudicating authority, my lord. In between, my lord, he passed away. Nobody, my lord, has followed that. His legal heirs did not follow that application, my lord. Now, my lord, in page number 11, now I am taking, my lord, to the Act why we are aggrieved. My lord, section 72 of the Act, in the last bottom, my lord, page number 11, we have just abstracted that whole thing, my lord. The 72, my lord. Where? The next page, my lord. Any person, any property of a person has been attached under section 8 and no appeal against the order attaching such property has been preferred. Then appeal, then B1, my lord. In case referred to clause A, such person dies or is adjudicated as insolvent before preferring an appeal to the appellate tribunal. Here he has preferred, my lord. So, next, my lord, in a case referred to the clause B, such person dies or is adjudicated to an insolvent during the pendency of the appeal, then it shall be lawful for the legal representative of such persons or of official assignee or official receiver, as the case may be, to prefer an appeal in the appellate tribunal. Here already he has appealed. The Act says that somebody has to. Once the property has been confirmed by the adjudicating authority, appeal lies in the tribunal. If he passes away, somebody has to file an appeal in the tribunal. Here he has filed. So the excise, my lord, he has to, somebody legal here has to continue with, my lord. So, my lord, at this stage, my lord, my only prayer is, my lord will issue notice. At this stage, let them come, my lord. We have read their legal here. My lord, issue notice, and only on this ground, my lord, will stay the proceeding for the proceeding of this, my lord, special court order, my lord. Just stay the. We are not going for anything, my lord.
Special court order was that it was already on the death of the accused. There is no continuance and as it becomes instructor and me.
But
now we want to stay with
no, my lord. Our application is for, my lord, 8-7. That has been stayed, my lord. My lord will come to page number 35. We moved an application under 8-7 for confiscation of the property, my lord. So that has been rejected, stating that the accused is no more. But, my lord, the act says otherwise. If he dies even, my lord, we have to follow that procedure of crime, my lord. So at this stage, my lord will just issue notice and stay this order, my lord. My lord, I have the act. If my lord requires the act, my lord, I have the act.
Write it out. Now, at present, I don't
Oh,
need
my lord, my lord.
art, your for
Enforcement Directorate, my lord.
Setting up for against the order 30, 12, unless with the Assam, Guwahati, regulatory emphatic case number 8 of security of the petition. It appears under section 8, 7 of PMLA for purpose of confiscation of property involved anyone from in the office of the money laundering. Notice. But sometimes heard that Granite would be not appreciate the fact that the or her ticket and but without considering the case, the order has been passed by rejecting the prayer of the present petition for confiscation of the property under section 8, subsection 7 of the according to the subsection prayer prayed for stay of the order dated 23/11. This order was 30/12.
30/12/23, my lord.
30/12. The matter after 4 weeks it will be decided.
My lord, 4 weeks, my lord. My lord, you should notice, my lord, we'll
Yes,
take steps.
yes,
We'll take steps, my lord. My lord, we prayed for a. My lord may fix a date, my lord, after 6/6. No issue, my lord. Deeply obliged.
It's a revision petition, Your Lordship, against check bounce cases. So, in this case, Your Lordship, the petitioner allegedly took a loan of 5 lakh rupees, Your Lordship. Thereafter, there were 3 separate check bounce cases were filed for 5 lakhs rupees each. In 3 of the cases, Your Lordship, this loan amount is shown as 5 lakhs and taken on the same date. However, 3 separate cases, there were 3 blank checks deposited and 3 were separately filed. And in 3 of the cases, there was a sentence of 6 months imprisonment and 7,50,000 fine in each case, Your Lordship. The other 2 cases are also challenged, Your Lordship. Those are also pending. And at this stage, since it is a revision petition, the complainant has to be heard. Notice may be issued, Your Lordship. Lordship, the impugned order may be stayed, Your Lordship. And it may be posted with the other 2 cases. There's Criminal Revision 179/2024 and 180/2024.
According to whom? So what are the other cases?
Criminal Revision Petition 179/2024
179/24
and 180/24.
All 3 registered.
Lordship, kindly the matter may be taken up after some time. Obliged.
May I please your Lordship? I filed this petition for quashing of charge sheet as well as proceeding in the PRC case, my lord. Kindly turn to the FIR, my lord. Page 18 starts, the 11 portion, page 19, my lord. May I read the FIR, my lord? With reference to the subject cited above, I have the honor to report that today on so-and-so, at about so-and-so received and secret information from reliable source regarding transportation of illegal liquor in Jodha vehicle from Hojai. Accordingly, general diary entry was made by me at Lahorizan PP by DD number so-and-so, and I immediately informed my superior officer, then self, along with so-and-so, conducted Naka checking duty on NH 36 in front of Lahorizan PP. During Naka checking at about 8:30 am, 2 number of Jodha vehicles bearing registration number so-and-so are coming from Dillai side towards Dimapur side was signaled to stop at Naka checking point, and both the vehicles stopped. On asking the driver of both the vehicles, they stated that the vehicle were loaded with eggs. But on thorough checking of both the vehicles by the Naka checking party found various brand of liquor kept concealed under the egg carton. During spot interrogation, both the namely Askar Ali so-and-so, Joinal Abidin of village so-and-so, MD Guljar Hussain so-and-so, and Shafiqul Islam so-and-so could not produce any document of said liquor. My lord, within these 4, I am not anyone. They also revealed during spot interrogation that they delivered the
Case has already been charged. No.
Case charge sheeted, my lord.
Against you also.
Yes, my lord.
Against you also.
I am the 4th accused. My lord, my humble submission that in a recent judgment by the Honorable Apex Court, it is held that while a report is submitted by police under section 173, 73(2) should be complied in strict sense, man. So, a specific role attributed to individual accused should be reflected in the charge sheet, my lord. May I take your lordship to the charge sheet for a moment, my lord?
My lord, at this charge not yet framed, my lord, charge sheet submitted. So my prayer before lordship, let him place all these materials at the time of framing charge. At this stage, my lord, this petition is liable to be rejected.
My lord, kindly come to
You
the
can
charge sheet, my lord.
you come to later on, but the question is that you can put it on a trial court video at the time of frame of charge.
Charge is framed, my lord.
Charge is already framed.
Yes, my lord. Charge framed. It is.
Hopefully you record on
Whether you have filed any application before the trial at the time
for
of criminal
discharge,
trial?
you have filed any application?
It is fixed for evidence
For your
now.
discharge. No, for your discharge.
The
At the time of
charge part already
consideration of-
gone, my lord.
No. At the time of consideration of charge, have you filed any?
No, my lord.
What?
Yes.
I was not properly guided by my. I was not properly guided by my advocate before the trial court, my lord.
That cannot be a ground, my lord.
Because there's chance. Because your name was not there in the
My humble submission is that let the record come, my lord, and till then further proceeding against me may kindly be stayed.
Not at all. Hard. Hard. Oh, it is the state only, na?
Yes,
State, my lord.
No problem. Call for can go. You're calling the case diary also.
Along with case diary, my lord.
So next date, your fixed date is when? It is fixed.
Next date, yes. 29 of this month. I think 29, my lord.
Definitely we have to fix it subsequent date. Otherwise, I thought that prior to
No, my lord, not
we could have
possible.
got, no,
Not possible.
not possible. So you want an fixed date here. Fixed date.
If possible.
28th of May. no? 28th.
May not give.
Oh, yes.
Do you think that
Yeah, yes.
reach?
On June, my lord, 19th of June, my lord. On 19 or 20, 20, my lord.
20.
20.
Oblige, my lord.
May I please, my lord?
Yes.
FR, my lord, English translation at page number 8, my lord. FR is given by a father alleging that her son had felt in love with a girl and the girl inflicted torture on her and that's why he committed suicide. That is the allegation, my lord. The fact is this, my lord. The accused person of this case, my lord, she is a law graduate and she is a law graduate. She has passed LLB 3-year course. I have annexed the certificate, page number 14, and I am likely to enroll as an advocate. And through social media, I came in contact with the person, this is Rasidul Haq. And in course of chats and these things, we exchanged some messages and it's a photograph. Later on, we met in City Mall. There I came to know that at the time of chatting, the boy had introduced me that he is a pharmacist and having a pharmacy. But in course of interaction, I came to know that he is not even a graduate, he is only a higher secondary pass and not even having any license for the pharmacy. Just some medicines he is selling them like that, but not a pharmacist. Then I refused the marriage proposal. That is the fact actually. Now, if by refusing the marriage proposal, if a person commits suicide, my lord, that cannot be said to be a abetment to suicide, my lord. By judgment, my lord, of the Supreme Court. Refusing marriage proposal, my lord, does not amount to abetment of suicide.
Parashar is appearing here. Who is appearing here?
Well, my lord, state is not a party, my lord.
State is party.
Oh, sorry, my lord, yes.
State party নহলে বেল কেনে হ'ব?
আমার sorry, my lord.
Page number, FIR page number 8. My lord, I have a right to accept marriage proposal or not to accept, my lord. In question of my life, my lord. And I also came to know that he is addicted, dead addicted.
All those things will come in the case diary.
Yes, my lord.
All 306 is there, so my lord, PD may be called for at least.
Meanwhile, my lord, I am a protector. I am a law graduate, my lord. If I am arrested, then my career will be hampered, my lord. I am likely to enroll as an advocate, my lord.
CD, my lord, your lordship will consider me. Because
That,
306
but
is there.
till then, my lord, at least till then, my lord.
We'll try to give a shortcut from where it has come.
Morigaon,
my lord.
Try to give a shortcut.
Yes, my lord.
My lord, police is regularly subject by my lord. Till then, my lord, I am a protector. I am a law graduate, my lord.
On 22nd of May, my lord.
I am likely to enroll
Before
myself
that,
as an
my lord.
advocate, my lord. Till then, my lord.
On 18, my lord.
If it is found in CD that
17th of May, 17th of May.
if in course of if in CD is found that I am guilty, then maybe but till then, my lord, at least.
We are calling case diary on 17th of May.
My lord, till then, at least, my lord.
Your lordship. Lordship, item 13 and item 6 are same, your lordship. This is anticipatory, your lordship. All are interim, your lordship. This is lordship order, your lordship. Another order. Similar order, your lordship.
Again, my lord, these persons in a group assaulted the police personnel.
Same FIR, your lordship. Item 6, your lordship.
6 will have again.
6 will look up. Then. 6.
Yes.
Earlier he was granted. One of the coaches was granted.
No, all accused person except me, your lordship. Annexer B2, Annexer G, your lordship. Of my petition, I have annexed. Annexer F, your lordship. Annexer B2, Annexer F. Page number 22,
This is your,
30.
Your this petitioner seeking anticipatory bail.
Anticipatory bail. Some protection may kindly given and fixed, your lordship. With this case, your lordship. I think 29 and 30, your lordship.
Other cases are listed on when?
That's some 21, your lordship.
21 of May.
And lordship, this order is, your lordship, that's maybe 29 or 30, your lordship.
This is 31st of May.
31st of May.
31st of May. Same order. Take it to submission. Overall is same. Submission of petitioner. This one is 31st of May.
Obliged, lordship.
Yeah, please, your lordship. Kindly better maybe pass over for timing, lordship. My senior is on legs, lordship.
Okay, number here. Kiman is the number?
Made please, your lordship. Lordship, case record was called for, lordship, and I think it is there. Lordship, in this case, lordship, I have been charge sheeted under section 302, lordship. In total, lordship, three witnesses are cross-examined, lordship, and lordship, except for the informant, lordship, they have not stated anything incriminating against me, lordship. And in the informant's version is, lordship, that I have called him and said that I have murdered the informant's father. That is the statement which he has given, lordship. Now, lordship, I was arrested in the year 2022. More than 1.5 years has elapsed, lordship. Now, lordship, I am ready to cooperate with any conditions given.
Here you have written as 23.
22. Oh no. Oh, I'm sorry, lordship. 2023, lordship. More than 1.5 years has gone, lordship. Lordship, my Lordship may give me any conditions and which is satisfactory, and maybe the bail bond, increased bail bond may be given, because there might be a caution that I am from West Bengal, so there might be a apprehension that I may not appear. So Lordship may give me any conditions which is necessary, because more than 1.5 year has gone. So and there is no substantial development in the case also, Lordship, incriminating me, Lordship. Lordship may kindly see the CD once, Lordship. Lordship will be clear. I have annexed the examination of chief of the 3 witnesses.
3 is the informant, my lord, Saddam Hussein. PW 1 and 2 are 2 VDP personals, my lord.
3 is the informant.
Informant, my
3 is the informant. He has not seen the incident, but according to him, I have called him and said that I have not.
And
That
before them,
is,
the my lord, accused person, my lord, admitted that, my lord, how these accused persons are involved, and thereafter, by killing, thereafter, my lord, killing the, my lord, victim, they poured petrol over the dead body, and thereafter, my lord, with the help of Jahangir Hussain, and thereafter, my lord, police arrested all these 2 accused persons from West Bengal, my lord, Darjeeling, my lord, while after the my lord, commission of the offence, my lord. And thereafter, the victim person Reza Ali, they in fact, my lord, sold the mobile phone of Reza Ali to one Pradeep Jha. Thereafter, my lord, police interrogated Pradeep Jha. He from the IMEI, my lord, of that mobile number. Later on, police came to know that this is the mobile phone of Reza Ali, and Pradeep Jha also stated that those mobile phone was provided to him by the one of the accused, Jahangir.
Lordship, these are statements which I have already made in the petition. These statements which my learned friend is referring to, I have already made these statements in my petition. But I have not Reza Ali. Neither I have sold the mobile to them. It's a page. Lordship may kindly see what is the FIR and then paragraph number 6. Lordship, I am not trying to say that the trial should. I'm not guilty or trial is wrong. No, I'm not on all these issues, Lordship. My simple point is that, Lordship, rightly or wrongly, some allegation is against me, and I'm cooperating with the entire trial. I'm for 1.5 months. I'm behind. For 1.5 years, I'm behind the jail. And Lordship, these things should be considered, Lordship. And I want the bail condition to be more if Lordship is not satisfied that I'm from West Bengal. I'm not denying the fact that I'm from West Bengal. But if that cannot be a condition to deny bail in the country of India, I'm an Indian citizen. If Lordship is thinking that I might not come from West Bengal, then if not 1 surety, give me 3 sureties. If 20,000 is not the amount, give me 3 lakhs. But mere saying that I am from West Bengal cannot be an apprehension for the court to deny me bail, especially when I am from 1.5 years I'm in jail. And after commission of the offence, Lordship, at that moment I was apprehended from West Bengal because I stay in West Bengal. I didn't come here and commit the murder. Whatever allegation, I'm not denying any of the allegations. I'm ready to face the trial. But at this point of time, while considering my bail application, how will I prove myself innocent when the trial is going on? I will prove my innocence in the trial court. Fairly submitting, Lordship, after 1.5 years, I'm praying, Lordship, a harsh condition may be imposed on me. I will appear and face the trial, Lordship. And I am facing the trial. If I may submit, Lordship, in the case of Satyendra Kumar until judgment, Lordship, it was also under 302, Lordship. The conditions has been mentioned by the Supreme Court, Lordship. This cannot be a ground that this cannot be a ground that because I am an under trial prisoner, I should continue to be in under trial, Lordship. If I am found guilty, I will serve the sentence. Why do I serve sentence now? Autónomo pedazo
Hello, otherwise, from the materials available till now, whatever material available in the, my lord, from the evidence of the two accused persons and from the materials available, they are, my lord, directly involved in commission of the offence, my lord. And, my lord, there is, my lord, chance of their, my lord, acquittal is, my lord, almost, my lord, nil. My lord, from the materials till now available from the LCR, my lord. So, my prayer before Lordship, my lord, till now only there, my lord, evidence prosecution, there are only taken 3 witnesses, my lord. Yet to be, my lord, other, my lord, vital witnesses yet to be, my lord, examined. So, at this stage, my lord, and there are, my lord, recently, my lord, I have not, regarding, my lord, length of detention in this type of heinous offences, my lord, these accused persons are, my lord, not entitled to bail at this stage, my lord. While there are sufficient material till now, my lord, from the, my lord, record, my lord, against the accused persons. And from, my lord, CDR analysis, thereafter mobile phone of the victim, my lord, and thereafter, my lord, these accused persons sold that mobile phone to the person, my lord. His statement is all, everything is available in the cases. So there are sufficient, my lord, evidence against the accused person. And, my lord, ultimately, my lord, definitely, my lord, from these materials, my lord, ultimately, chance of acquittal is almost nil, my lord.
So, my lord, may I submit, Lordship? No, Lordship, if I didn't bring the judgment, Lordship, I'm sorry, Lordship. But I was anticipating these kind of submissions, Lordship. Now, what I have also gone through, because I'm, fairly speaking, Lordship, I have also seen these evidences, Lordship. Lordship, if you see in page number 19, a total 9 witnesses are there. Out of 3 has been examined. Lordship, may kindly see these other witnesses. 4 of them are police officers. The same police officers who have investigated the case. Now 4 witnesses plus 3, or 7 already went. Now chances of an independent witness saying something is almost nil, Lordship. Now what my learned friend has submitted, that there is almost no there is no probability of getting an acquittal. How can that submission may be considered at this stage, Lordship? Indian system is very clear. Until unless the court finds me guilty.
They are from West Bengal.
Yes.
Lordship,
and, my lord, victim's mobile phone was
yes,
also
Lordship,
recovered from there. One Pradeep Jha. He is from West Bengal, my lord.
No, Lordship,
and the person is
I understand I am from West Bengal. I have always understood that I am from West Bengal. That is the reason why Lordship's apprehension would be what, Lordship? That I may not come back. That is the apprehension.
And my lord, one of
No,
the
Lordship, that
vital-
is the reason. First, while submitting only, Lordship, I have submitted that a harsh condition may be imposed because a person who is in West Bengal is not entitled to bail. Firstly, because that cannot be a ground, Lordship. Whatever my learned friend is objecting to, that objections are not ground for not granting me bail, Lordship.
And my lord, one of the vital witness, Pradeep Jha, his statement, my lord, not
Now,
yet.
his statements has already been recorded, Lordship. Now,
His deposition is not
His
yet, my lord.
deposition is he has deposited before
Not
the
yet
police.
Before
Now,
the police.
now if it's an apprehension that I may go to today and that witness I may threaten him, then conditions may be imposed. But with an apprehension that I may do so, and a person is from here, I am from West Bengal, I will come from West Bengal and threaten him here. So these are submissions which are made out of the blue air. There is nothing to controvert such submissions. All I am saying is that, Lordship, I wanted to be logical in my submission, Lordship, not saying something which is out of proportion. I might come from there and I might threaten. All these are apprehensions. If my personal liberty will be jeopardized because the learned PP is under apprehension.
No, my lord, I am
Can
not under apprehension.
can
One
that
of
be
the
a ground,
vital
Lordship?
witnesses,
No,
my
I am
lord,
thinking
Pradeep
for
Jha.
myself, Lordship. Can that be a ground for denying me bail? I am an advocate sitting in Guwahati High Court. I have apprehension that he might do something, and that is the reason a person's right under section Article 21 will be violated. I am trying to make reasonable submissions only. The rest I leave it to your Lordship, Lord. But my submission is very logical, Lordship. If the apprehension is real, then harshest condition may be imposed. But my personal liberty may be safeguarded. That is my only submission. I don't want to commit anything on the trial, how it has happened, if I will be found guilty or innocent. These are matters to be decided by trial court. I have nothing to say and I will try to prove my innocence. If I am not proved innocent, then I will serve the prison or whatever the sentence will be. But at this moment, why should I be extended for prison without there being any evidence against me, Lordship? And how can anybody say that tomorrow there will be a conviction against me without only 3 witnesses examined? 4 of them are police only. All I am praying, Lordship, is to grant me a bail and harsh condition can be imposed, Lordship.
My lord, one of the vital witness of the case is Pradeep Jha. Pradeep Jha is not yet examined. There is every possibility of, my lord, tampering or hampering, my lord, with the, my lord, that
Then
witness Pradeep Jha.
there is a different system of protection of witness.
My lord, why should, my lord, at this stage, my lord, while that vital
That
witness
cannot
is
be
yet
a
to
ground,
be
Lordship.
examined,
In
while
my
you are
humble
involved
submission,
in,
that
my
cannot
lord,
be a ground for rejecting my bail, Lordship. If I have a history of threatening the witnesses, that is also a different thing. Can anybody say that I have a history of threatening witnesses?
my lord, every criminal is not, my lord, required to be have a history, my lord, long history, my lord. Here, my lord, there are sufficient incriminating materials from the case diary.
Or in a list of witnesses, there is nobody as Jha. And Jha is a bus conductor, Lordship. How can he be a material witness? I have committed, according to the prosecution, I have committed the offence in West Bengal. Now Jha is a bus conductor. Now how can he be a material witness?
Your Lordship may kindly peruse, my lord, paragraph 21 of this judgment. Your Lordship. Recently এটা লাইভ লো ওলাইছিল এইটো হেঙা পৰ্যন্ত
And recently, my lord, one decision is also passed by the Supreme Court in, my lord, that length of detention cannot be a ground for, my lord, granting bail in this type of serious offences, my lord.
But if I may, my learned friend is referring to judgment, I would like to refer to the judgment of Satyendra Kumar NTL Lordship, and that is the pivotal case of which the present bail and under trial has been.
Anyway, my lord, from the materials available on record, my lord, at this stage only vital witnesses not yet examined. There is every possibility of hampering or tampering with the evidence. So, my lord, in considering the available material, my lord, at this stage, my lord, my prayer before Lordship not a take place for granting bail.
Lordship, may kindly just if Lordship may, I'll just I'm understanding and I can also understand the apprehension of my learned friend. I'm not saying that, Lordship. But the only thing fairly submitting, Lordship, at this in today's circumstances, Lordship, the judgments which has been relied by the Supreme Court with regard to the bail is very lenient, Lordship. I understand the apprehension, Lordship, but Satyendra Kumar NTL Lordship, it has been clarified that all these kind of under trial, ultimately I'm under trial prisoner. Now, when I am an under trial prisoner, Lordship, I cannot be forced to serve a sentence. Previously, it was a condition. Previously, before 2000s, Lordship, it was a condition that you can serve now. Tomorrow, after your sentence is given, that period will be reduced, and so you can serve lesser sentences after that point of time. But nowadays, the views of the Supreme Court and also the law has changed. They are now saying that why to force you to do something which you might not, or after some time you can. Now, in this case, Lordship, suppose today I will be convicted. I will anyway suffer this, Lordship. What I am suffering now, after that will be reduced. It is not a case that I will not be suffering. But my only thing is that why should I suffer in the year 2024 when I am not guilty or when I have not been convicted? Or that is all my apprehension, Lordship. And Lordship, if Lordship query or Lordship might think that I might abscond and never come back, then harshest condition may be imposed, Lordship. A bail amount of 4 lakhs may be given or more, Lordship. But Lordship may kindly consider me, Lordship.
Regarding now his submissions, I will also provide one judgment, recent judgment of the Supreme Court in Shibani Tyagi versus State of UP. I will provide one copy of that.
I will also provide, Lordship. I'll do.
May I please you, Lord? The matter really is a transfer petition from Bongaigaon to Guwahati, my lord. What happened? I take to Lord. The petitioner is a railway employee, my lord, and a proceedings, a divorce case is pending at Guwahati, family court, and where the wife is regularly attending. Then, my lord, she filed a case of 125 at Bongaigaon. Then, my lord, what happened? My lord, I am working in a essential service. I take your lordship page 23. 23, kindly. That's Sri Devashish. 23, Devashish Bhattacharya, designation technician 3, C&W Kamakya office of the carriage coaching depot, Kamakya, working in train passing Kamakya under such and such station. He is serving under essential services of Indian Railways, and it is tough in the part of the railway authorities to grant him station leave as his work falls under the essential service of the Indian Railways. This is one. Then, my lord, I take your lordship. I met with an accident while I was working in this railway track. Page 25, kindly. Page 25, kindly. This is to certify that my mother, my Swapna Bhattacharya, age of 69, has been under my treatment since last 1 year, following severe lower back ache, following chronic lumbar problem, my lord, and this lesion.
His
With-
mother.
Yes, mother. It is my mother. There is none in my home. Mother is alone. Then, my lord, page 26 is the certificate that at Maligaon that the regarding the how I met with an accident, my lord. And there is direction that till 6th of June 24, I have to take a rest, my lord, bed rest. Page 26, my lord, bed rest. Then, my lord, page 28, your lordship will find, NF Railway Maligaon, my lord, how the Devashish Bhattacharya suddenly got injured on his left leg, ankle while performing duty, T number such and such, line number 6, at train passenger. So, my lord, I am under...
Now, your one case is pending before
before the judicial court at Bongaigaon.
and 125.
I want that it should be get Guwahati, madam. If necessary, madam, I will pay her
Divorce petition is pending
at Guwahati.
Guwahati.
She is attending in that case.
and other one she filed at 125 with
One at Bongaigaon, she has, my wife has filed. If necessary, I am ready to pay the fare of the train fare.
now.
First question, I am essential service, railway authority is not allowing me to leave. Then I am suffering from injury, my lord, up to June. I have bed rest, June 24. Then hardly my wife, my mother is alone, my
Your
lord.
petition will be allowed by the court below if you have some such kind of medical emergency. Now we are issuing notice to the respondent number 2.
Yes.
Sorry, respondent.
Yes.
Pending sub Bongaigaon and section 125 report of Okay, you.
My lord, I pray for interim stay, my lord, kindly.
Why? What is the stage of this case? That they are,
No, only notice stays, notice, my lord.
Notice.
Yes. Stay, interim stay.
Not required. Notice. Skip of 1 day. We are giving in 3 weeks time only, not 4 weeks. 3 weeks.
Three,
3 weeks.
stay for 3 weeks, kindly.
No stay. 3 weeks time. 3 weeks. It will be listed after 3 weeks only.
But I have
Take steps.
I have to attend. There is the date is fixed, my lord.
You attend once. No. After 3 weeks.
Some interim protection will be given away. I will not get the leave. Up to June, I am on bed rest. So how can I go, my lord? Till June, I may be given.
advised to take it after this next week.
May please, Your Lordship. My Lord, I am sorry to state one thing, my Lord. In between, there was no electricity. The display board was not functioning. So, item 38, I missed it, my Lord. Item 38, my Lord. CD was there, my Lord. I am on the interim, my Lord. I was on the interim. 38.
38 not yet called.
Oh, sorry. He told me that it was called, my Lord. He told me that it was called.
May I please, Your Lordship?
439 application, Your Lordship. Lordship, the petitioner was arrested on 20 March 2024, Lordship. As on date, 52 days behind the bar, Lordship. The allegation was, Lordship, under section 489B and 489C of IPC, Lordship. Case diary was called for, Lordship.
So altogether, Lordship, fake Indian currency notes amounting to 47,000 of 500 denomination was seized from his presence, Lordship. He was caught by the public, Lordship. He was trying to pass one fake currency note to a shopkeeper, and he realized that it is a fake currency, and subsequently, with the help of the local people, he was caught. And then the police was brought to the spot, Lordship, and they found 47,000 rupees in total from his possession, Lordship, all are fake currency. And Lordship, from his statement, Lordship, he has named another co-accused who had given him the fake amount to be circulated, Lordship. And Lordship, now 52 days there, Lordship. That person has not yet been arrested, Lordship. It is the status of the case.
Lordship, my submission is I have made a scapegoat, Lordship. That person already I have told before the investigation agency, Lordship. And that he gave me. Actually, Lordship, not to circulate, Lordship. Actually, he taken the money on exchange of online transaction, Lordship. He said that he required some cash, and like this he has taken, Lordship.
Is there any such kind of?
And Lordship, it appears in the Caesar list also, Lordship.
Is there any that he?
He was fully aware, Lordship. He was told that you give me 15,000, 1,500, and I will give you 50,000 of fake currency, Lordship. Then you can use those 50,000. So obviously he knew that those notes were fake. Otherwise, who will give 50,000 for 15,000?
As per the Caesar list, Lordship, it is appeared that all those notes are the copies of, Lordship. 34 norms of 500 notes are the same serial number, Lordship, and another 19 notes and another 29 notes. All are. It is appeared that the money was scan copy or Xerox copy, maybe, Lordship, which is not amount to fake currency, Lordship.
No, that is not clear, Lordship. He was trying to pass it off as genuine. No, FSL not because report.
Moreover, Lordship, I am 52 days behind the bar, Lordship. I have already undergone 3 days of police custody also, Lordship. And this custody days, Lordship, police has never came for my custodial interrogation also, Lordship. So my custodial interrogation may not be required, Lordship, as I have already undergone long period of detention, Lordship. Moreover, Lordship, I am a government servant, Lordship, and my identity card is I want to submit, Lordship.
You are a government servant.
Lordship.
As part of being a government servant, you are doing all these things.
Lordship, actually.
Very nice. And schoolmaster.
No, Lordship.
Good teacher or what?
What? Khalasi, Lordship, Water Resource Department. Lordship, I'll appear as and when required before the IO, Lordship. Even day to day, I am ready to appear, Lordship. I'll cooperate with the investigation. I have all ailing parents, Lordship. And I am local residents of Guwahati, Lalganj, Lordship. There is no chance of being absconding, Lordship. Stringent condition may be imposed, Lordship, but
meet that guy. 1%. What? That it. It becomes. What is that? You give it online, transaction was online.
Lordship.
Huh?
Submit.
What? And since when you were
Lordship, 20 March. Lordship, surety. Lordship.
one? He is from where?
Lalganj, Guwahati. Lordship.
One.
Yes, ma'am. CGM Kamrupet. Highly abreast.
Case diary not received.
My Lordship, 439 application, my Lord.
Since when you were custody?
My Lord, 25 days, my Lord. He is 66, already victim card has been recovered, my Lord. But custodial detention is not required, my Lord. Already 20. My Lord.
CD not available.
From where the thing girl has been recovered?
My Lord, from the FIR, my Lord, page number 14. And the order sheet also, my Lord. Page number 70. I am a diver, my lord. But there is a love affair, my lord. There is no case of 366, my lord. My lord, page number 10 is my driving license. My lord.
There's an overlapping. Where is the forwarding report?
Forwarding report, my lord. It's 16. 16, my lord. It's 16. 16 process. Last night.
Next item.
Mr.
Arborwal.
Mr. Arbor.
Deeply over. Number of Macam. Deeply over.
21 also, Lordship, CD has not been received.
Or 39 application matter. This is a 27 days in the jail also. And FIR is a test for it.
376, I think.
Yes.
The thing is also they have the lab affairs also, and when the accused refused to marry lordship, then
Not only 377, not there. Why he is there in
No, Lordship, it's come again from Hajo, Lordship. A lot of the time, Lordship, we are seeing that Hajo police station is not cooperating.
You get into remanded one.
Lordship.
Second
also
time I
just 1.91 case 30 also, that is the forwarding report. The police has mentioned the ground of arrest also, if not arrest, local people may threaten him also. Therefore, he was arrested also. They have lab
we're
affairs
just
also.
fixing on next week only.
Lot.
Next week is
17, Lordship.
7.
Also, Lordship, CD not received. It's under 392, Lordship.
May I have his election? Here the petitioner number 1 has been in jail since 25th March and petitioner number 2 since 28th March. A similar sum of one accused has been granted bail yesterday by your lordship and AB 1070.
City is there.
Yes, Lordship. After perusal of city,
No, that means city is available.
maybe, Lord.
Actually,
If city is available.
Lord. Habla.
City also Lordship, he did not receive. Next week also anything?
If I may, subject to what my friend says, if I may take the Lordship to paragraph 2 of my petition, Lordship. Here is a case, Lordship, where some land mutation was alleged to be done in my name by a vicious circle, and there is an allegation that I am also involved there. Subsequently, the complaint, after a complaint was filed by the complainant, that has again been rectified. As of now, the land which was supposedly mutated in my name is in the name of the complainant. Even after that, the complainant files a FIR and states that I am threatening the complainant that by the help of the previous mutation, I am going to transfer the land. Now, Lordship, if there is any transfer of land, the records will always be Peru's, Lordship. How can I be implicated in that offense? Now the records are also already corrected. And if I may take your Lordship to page page 14. Page 14, this is the forwarding report. I have been arrested on 7/4. If I may take your Lordship to point number 10, just under the seal. Point number 10. The signature of the arrested accused person found in the application for mutation by case number so-and-so seems similar to the specimen signature collected for examination. However, the genuinity of the will be provided by the express of the FSL. In any case, Lordship, if the FSL finds that yes, there is a similarity or I have signed the document, I am ready to face the trial. But as on date, the mutation record stands in the name of the complainant. For that, Lordship, I cannot be kept behind the bars.
The case.
No, Lordship. Let it be in the next week, Lordship.
Yes,
However,
next week any date.
Let it be on Wednesday. If not.
Wednesday.
So,
If Wednesday is 15. Okay, we'll fix it.
So,
What's the problem? Was there any
yes,
subsequent mutation application or not?
Yes.
We'll practice.
In fact, Lordship, what has fallen from my client was contiguous land belongs to my client. He filed an application for correction of that. Somehow or other, maybe the number of the other land crept into this one. Maybe.
Otherwise, your petitioner works where?
He's not working. He's not.
a.
He's a businessman.
May I please allow?
Yes, CD received.
Okay, 439 application.
Yes.
Allegations are under section 447, 448, 325, 392 and 34. That's it. That's it. As of today, 52 days behind the bar. 60 days offense. That's it.
Injury report received simple injury by plantation. Already 51 days.
52 days. 52 days.
were being arrested on when?
20,
Arrested on
23, 23, 24. CGM Dorong. Dorong.
Okay, you will tear up.
Oh, bless you. Hey, please, Lord.
25 first?
25 Lordship and 53.
The public was 25?
First, 53 maybe taken. Or 25.
One, 52.
Lordship, the petitioner is in custody since Lordship 17 March 2024. As on today, Lordship 55 days in custody, Lordship.
90 days offense.
90 days offense. And Lordship, FIR Lordship will find at page number Lordship 12. Page 12 Lordship. This is also LS recovery of Lordship that fake gold. Page 12 Lordship. May I read the FIR? This is to inform you that an information has been received from a reliable source that when I and IC Bongalmora along with staff were at a Naka checking at Bongalmora near petrol pump, the two persons were carrying suspected fake gold on a motorcycle, TVH Apache bearing registration number so and so. As soon as we received the information, we along with the staff waiting and looking for the above mentioned motorcycle at Naka checking. After some time, we have seen the motorcycle coming towards us and told them to stop. I along with staff searched the body and also the bag of the alleged persons at the spot in presence of local people. During search, two suspected fake gold both has been recovered from the bag which was carried by them. After that, I have apprehended both the alleged persons, namely Saiful Islam, son of so-and-so, and Khusidul Islam, son of so-and-so. I have seized the two boats made of suspected fake gold, weighted 1.485 kg and 1.835 kg respectively. Weight measurement was done with the help of weight measurement kit. I have also seized the navy blue color Apache motorcycle bearing registration number so-and-so on which they had carried the suspected fake gold. I have seized mobile phones of both the alleged persons, details of mobile phones as one Realme so-and-so Lordship, then mobile number so-and-so. Seizure was done in presence of witness observing all the formalities. During verbal interrogation, they stated that they were carrying the suspected fake gold to deliver to a person namely Gulzar Hussain of Lalu, who is involved in fake gold business. They have also informed us that many persons involved in this fake gold business and cheat people by selling this fake gold across the state. So initially, Lordship, fake gold was there, Lordship, not fake currency. And the FIR was registered under section 120B, 406, 420, 34 of the IPC. Later on, Lordship, 489B and 489C were added, Lordship. Because, Lordship, from one Lordship accused, certain fake currency were also recovered. And Lordship will find that page number 23, Caesar list. From Lordship Nur Muhammad, the 30,000 Lordship fake Indian currency was recovered. Because of this, Lordship, the 489B and 489C were added, Lordship. But from the present petitioner, nothing was recovered, Lordship. And he was arrested on the statement of the co-accused person. Nothing was recovered. And all the seized articles have been already seized, Lordship, including the Lordship fake currency. So my humble submission is that Lordship 55 days in custody, Lordship, and he has been thoroughly interrogated, Lordship. Articles have been, Lordship, seized, and no recovery from the petitioner, Lordship. He may be allowed to go on bail, Lordship.
Otherwise, my lord, your lordship has earlier, or many cases, your lordship has perused, my lord, came how this person are involved in a group, my lord, regarding, my lord, by providing fake gold, how they cheated those, my lord, various victimized persons, my lord. Now, in this case, regarding Mugdadul, initially, my lord, one Saiful and my lord, Khurshidul was arrested. Thereafter, during investigation, police has arrested many other accused persons, my lord. Later on, my lord, section 489 B and C added, on the basis of the statement of the present accused persons, my lord, one of the accused, Nur Muhammad house, was charged, and thereafter, my lord, one, my lord, fake, my lord, currency machine was recovered from the house of Nur Muhammad on the basis of the statement of the present accused. Thereafter, my lord, section 489 B and C was added, my lord.
In this case, Lordship, the FIR is lost by the Lordship, that police, Lordship, of the outpost.
But he knows that Nur Muhammad has victim.
Yes, man. So he is directly, my lord, involved along with all other accused persons. So on the basis of his statement from the house of Nur Muhammad, that, my lord, fake currency machine was recovered, my lord. Nur Muhammad আছে সাবস্ক্রিপ্ট নগৰ Nur Muhammadৰ ঘৰত এটা টকাৰ মেচিন আছে there he also admitted আমাৰ গ্ৰুপৰ leader Baharul Ambani, Saiful, Khurshidul, Mufidul and many other he admitted and also revealed many other names of the other accused persons and thereafter my lord Nur Muhammadৰ ঘৰত এটা টকাৰ মেচিন আছে thereafter police searched the my lord residence of Nur Muhammad and my lord from the house of Nur Muhammad that my lord recovery was made, my lord. And thereafter, my lord, 489 B and C, my lord, added in this case.
That is also accused statement, Lordship, whether there is any independent...
Thereafter, my lord, recovery was also made, my lord, from the residence of Nur Muhammad.
Whether, Lordship, there is any independent corroboration, whether any independent witness, Lordship, that Lordship has to look into, Lordship.
So, my lord, from the materials available in the case diary regarding the against the accused person,
that 489B cannot be
90 days offense, my lord.
489B cannot be, Lordship, cannot come into play in this case because Lordship, whether any victim has been Lordship identified, that Lordship has to see, Lord, because it is a FIR lost by the police, Lordship. Whether anyone has been cheated, Lordship, only then Lordship 489B will come into play. Otherwise, 489C is available.
That will come at the time of trial, my lord.
Machine is there, Lordship,
yes.
But whether anyone has been cheated, because before Lordship that Lordship that machine was recovered, before anyone could be cheated. So in my humble submission,
all those things come, my lord, during trial, my lord. But from the material still now available in the case diary, my lord.
Lordship, may kindly see 489B, Lordship, for a moment. B, Lordship, using as genuine forged or counterfeit currency notes or bank notes. Whoever sells to or buys or receives from any other person or otherwise traffics in or uses as genuine any forged or counterfeit currency note or bank note, knowing or having reason to believe the same to be forged or counterfeit, shall be punished with imprisonment for life or with imprisonment of either description for which may extend to 10 years and shall also be liable to fine. So whether anyone has received that, Lordship, fake currency, alleged to be fake currency, Lordship, or that Lordship has to see, Lordship, 489B, whether it comes into play, Lordship. Otherwise, the mere adding section will not do, Lordship, because before anyone could be, Lordship, given that fake currency, the recovery was done, Lord. Everything has been recovered.
Is still going on, my lord.
Going on, Lordship.
Those things will come, my lord.
55 days as on today, Lordship.
At this stage, my lord.
55 days as on today, no recovery from the house of the petitioner.
These persons are from the area Bihpuria, Lakhimpur, Lordship. Earlier also faced many cases how these persons are. And in all these cases, my lord, only after, my lord, many victimized persons already in many cases there are, but regarding in this case on the basis of specific information, police initially, my lord, arrested first two accused persons. Thereafter, during investigation, name of all these accused persons revealed, and during investigation, all these fake currencies also recovered. from their statement.
But Lordship, coordinate B and 420 cannot come into play, Lordship, because had there been any victim, Lordship, then Lordship coordinate B would have come, Lordship. But in the Lordship absence of that, Lordship, I failed to identify any victim, Lordship. Only there before I fairly submit that before, Lordship, anyone could be cheated, the entire article have been seized, including the machine and all fake currency and all, Lordship. And coordinate B is very specific, Lordship.
All those things will come during trial. From Nur Ahmed residence, total 30,000 fake Indian currency note. Thereafter 8,500 one side printed fake Indian currency note. And one currency sewing machine used for cheating people.
$55 days.
Your 53 is the
25 Lordship, similar Lordship, only 27 days in custody. Otherwise, nothing recovered.
Yes, my lord, 25, he is also my lord, member of the group, my lord. He in fact stated, মই বাহাৰুলৰ লগত মিলি কাম কৰিছোঁ, বৰ্তমান বাহাৰুল জেলত আছে, এইভাবে কাম বন্ধ হৈ আছে। মই ভাৰতৰ বিভিন্ন মানুহৰ লগত ঠগ প্ৰবঞ্চনা কৰাটো সত্য, এই কাম মই অকলে কৰিব নোৱাৰোঁ। And thereafter, my lord, from his mobile phone, police has also seized his mobile phone, and from his mobile phone, various photographs of various my lord, fateful articles, my lord, তেওঁৰ মোবাইল ফোনটো চেক কৰি ফোনৰ বিভিন্ন ধৰণৰ ফোনৰ নামৰ ফটো মেলত পোৱা গৈছে। That is the note of the IO mail. So he is directly involved by my lord showing those my lord fateful items, my lord. He cheated various persons, my lord. And he other accused persons also my lord stated the name of the present accused person. And the present accused was arrested only on 14/4/24. Still my lord investigation is
27 days, Lordship.
There are many things yet to be recovered as per the note of the.
For fake gold, Lordship, 409 B will not come. For fake gold, so at best 420, Lordship. Lordship may kindly consider the length of detention, Lordship, 27 days.
what? 25. And he said
On
On Lordship, 14/4.
24.
Obliged. Lordship, both are rejected.
Both are.
Okay.
Right, please, Lord. Here, my lord, this is my lord criminal petition for my lord washing of my lord criminal proceeding, my lord, against the petitioner, my lord. Here, my lord, petitioner is my lord practicing
What
at
affidavit you have received that?
Lordship, my lord. I have filed my lord, perhaps that may be received, my lord. Here, my lord, petitioner before Lordship is my lord advocate by profession, my lord, practicing in Golaghat Court, my lord. Here, my lord, the wife, there is a matrimonial dispute between the opposite party number 2 and his wife, my lord. And the petitioner, my lord, being a advocate, my lord, has represented, my lord, the wife, my lord, in the court of Golaghat, my lord. And the wife of the opposite party number 2 has filed 3 cases against the, my lord, opposite party number 2, my lord. And those cases are, my lord, in one case, my lord, under section 498A, my lord. And another case is, my lord, under DV Act. And another one more case is, my lord, under section 506 395 of IPC, my lord. My lord, Lordship, may kindly take to page 17, my lord. This is the first case, my lord, filed by the wife of the opposite party number
2, my lord. And the petitioner is representing the wife of the opposite party number 2, my lord. Wife of the OP number 2, my lord. Page 17, my lord. Here, my lord, CR case number 03/2023, my lord. Plavita Thangal, my lord. She is my client, my lord. And my lord, name of the accused, my lord, down below, my lord. Madhusudan Gogoi is the, my lord, husband of the OP number petitioner's client, my lord. And this case is filed under section 498A, 323, 294, 34, and 506, my lord. And my lord, I have also annexed the Ukalatnama, my lord. Page 24, my lord, can you see, my lord? Page 24, my lord, Ukalatnama, I have annexed, my lord. I am, my lord, Sri Vikas Talukdar, my lord. I am representing the wife of the OP number 2, my lord. And accordingly, my lord, another 2 more cases has been filed by the wife, my lord, or wife of the OP number 2, my lord, at page 28, my lord. Page 28, my lord. Second case, my lord, under section DVAC, my lord. Page 28, my lord. Plavita Thangal is my client, my lord, and Madhusudan Gogoi is the, my lord, OP, my lord. This case is under, my lord, DVAC, my lord. And in this case also, my lord, I am representing the wife of the OP number 2, my lord. And third case, my lord, at page 52, my lord. Page 52, can you see, my lord? Page 52, third case, my lord. And this was also filed by the wife of the OP number 2 against the OP number 2, my lord. Page 62, my lord. Third case, page 62, my lord. This is also, my lord, under section, my lord, some of the section of, my lord, IPC 506, 395, 325, 294, 34 of IPC, my lord. Now, my lord, kindly turn to page 66, my lord. The OP, my lord, file an FIR, my lord, against the wife and his relative, my lord, and also, my lord, uttered by name in summary, my lord. Page 63, vernacular, your lordship may take at page 73, my lord. This is the present proceeding, my lord, against which I am come, my lord. Page 73 is the vernacular, my lord. May read, my lord. This is on, my lord, 10/7/2023, my lord. সন্মান সহকাৰে জনাও যে মোৰ পত্নী শ্ৰীমতী প্লাবিতা ঠেঙাল 25/12/2022 তাৰিখে মোৰ ঘৰৰ পৰা মোক শ্ৰীমতী সাবিত্ৰী ঠেঙাল আৰু ভাই শ্ৰী বিকাশ ঠেঙালে আহি লৈ যায়। বৰ্তমানেও মাতৃগৃহতে আছে। যোৱা 17/6/2023 তাৰিখে দিনৰ প্ৰায় 1 মান বজাত মোৰ ঘৰলৈ আহে শ্ৰীমতী প্লাবিতা ঠেঙাল মাতৃৰ লগতে 4জনকৈ গুণ্ডাৰ লগত লৈ আহে আৰু কয় যে গোলাঘাটৰ মহামান্য আদালতৰ পৰা মৌখিক অৰ্ডাৰ লৈ আহিছে আৰু নথিপত্ৰসমূহ বিচাৰি আমাৰ স্থানীয় গাঁওবুঢ়াক জনায় আৰু আমি গাঁওবুঢ়া আৰু কোৰ্টৰ আদেশ অমান্য নকৰি সন্মানে নথিপত্ৰসমূহ সমঝাই দিয়া হয়। সেই সময়ত সুযোগ বুজি শ্ৰীমতী সাবিত্ৰী ঠেঙাল আৰু শ্ৰীমতী প্লাবিতা ঠেঙালে আমাৰ ঘৰৰ ভিতৰত সোমাই LICত দিবলৈ গোটাই থোৱা 20,500 টকাৰ লগতে সোণৰ অলংকাৰ হিচাপে কাণৰ ফুলি এযোৰ আঙঠি এটা ৰূপৰ চেইন এডাল সহিতে সোণৰ লকেট এটা মনে মনে চুৰি কৰি লৈ যায় আৰু মই দুয়োগৰাকীয়ে ভিতৰৰ পৰা ওলাই অহা দেখা পাওঁ। আমাক নজনাকৈ কিয় ঘৰৰ ভিতৰত প্ৰৱেশ কৰিব বুলি সোধাত শ্ৰীমতী সাবিত্ৰী ঠেঙাল আৰু তেওঁৰ সহযোগীসকলে আমাৰ ঘৰৰ সকলো ব্যক্তিকে লক্ষ্য কৰি বেয়া বেয়া ভাষা প্ৰয়োগ কৰি গালি গালাজ কৰাৰ উপৰিও আমাৰ বাৰীৰে কোৰ এখন দাঙি লৈ মাৰিবলৈ আহে আৰু শ্ৰীমতী সাবিত্ৰী ঠেঙালে মোৰ 10 মহীয়া ভতিজা শ্ৰী দিব্যজ্যোতি গগৈক প্ৰাণে মৰাৰ চেষ্টাৰে গুৰুতৰ জখম কৰি মূৰত আঘাত কৰে আৰু তেওঁৰ সৈতে থিতাতে সংজ্ঞাহীন হৈ পৰে। তেতিয়া সকলো ঘটনা আমাৰ গাঁওবুঢ়া শ্ৰী হিতেশ্বৰ চুতীয়াক প্ৰত্যক্ষ হ'ল। Up to this, my lord, there is no allegation against the petitioner, my lord. Now, my lord, next paragraph, my lord. মহোদয় বৰ্তমানেও নিম্ন উল্লেখিত পাদুকীয়াগণ আমাৰ ঘৰৰ আশে পাশে ঘূৰি থকা প্ৰত্যক্ষ কৰোঁ। 5 নং আৰু 6 নং পাদুকীয়াগণ I am, my lord, accused number 6, my lord. শ্ৰীমতী প্লাবিতা ঠেঙাল আৰু শ্ৰীমতী সাবিত্ৰী ঠেঙালক পৰিচয় দিয়াৰ উপৰিও আমাৰ ঘৰৰ সকলোকে ভুৱা গোচৰ দি জেলত ভৰাই থোৱাৰ উপৰিও মোৰ ভতিজা শ্ৰী দিব্যজ্যোতি গগৈক অপহৰণ কৰি নি মাৰি পেলোৱাৰ ভাবুকি আছে। In this part, my lord, my name has been done. Accordingly, my lord, investigation has been, my lord, initiated, my lord, and upon completion of investigation, searches has been submitted, my lord, including the, my lord, petitioner, against the petitioner. Now, my lord, absolutely, my lord, this is a false case, my lord, only to, my lord, divert, my lord, my client, my lord, from providing legal service, my lord, my name has been attended. And accordingly, my lord, cognizance has been taken, my lord, and process has been.
Otherwise, my lord, there are many cases between husband and wife, but here the main content is at page 74. He has pointed out. Pass out, so he is accused number 6. 5 nong or 6 nong Kudukia, probably my lord from the vernacular it reflects it later on edit. My lord.
Now it case has already been started.
Second,
Summons
issued, my lord. In the appearance test, my lord, and next day is, my lord, on 2005, my lord. So, my lord, let the, my lord, call, city may be, or my lord, record may be called for, my lord, and my lord, as an interim measure, my lord, and making, my lord, protected, my lord. Is this so far the petitioner is concerned, my lord? Okay, bro.
The board of code is the 480.
42, my
But with the
in him,
can it be a bit under 480? Right?
Yes.
Not compoundable or not compoundable.
Yes,
Right?
my lord.
That's compoundable. Right?
Yes, compoundable offense.
I don't know, 5 to 6
Because my lord, along with 506, 323 is there. So my lord, main section is 323 compoundable.
Okay, my lord, I have prepared, my lord, under section 42, my lord, the Indian power of this honorable court, to my lord.
Yes, my lord. Yes.
not compoundable. Then
Even then, my lord, this court has the power, my lord, under section 42.
both has power. In respect to your case, in respect to your part.
My part, my lord.
Yes.
And it's white square.
Itu tuh semua itu কিন্তু তোমার এইটা তো রাখতে হবে এই প্রসেস করতে মানে My lord, this case, my lord, sections are, my lord, 380, 326, 307, 506, 109, 34 is also there, my lord.
Then why?
My lord, cost title, my lord, that is not specifically mentioned, but from page 69, my lord, the present affair.
69.
Page 69, the present.
No, my lord, charge sheet has been filed, my lord, under those section of law. Lordship may
yes.
find, my lord, page 77, my lord. Page 77, my lord, charge sheet, my lord. Page 77, first backup, 10 point, my lord. Under section 294, 323, 506, 34.
But where from your state that
FIR initially, my lord,
registered.
380, 326 are.
Yes, my lord, charge sheet, file under section 294, 323, 506, and item number 56 of supply, same case, very much. Along with 27, can be taken.
Lordship, case lordship regarding the FIR on page 20 lordship, says lordship that regarding some land dispute lordship, one plot of land was supposed to be agreement for sale was made lordship, some amount was given, and thereafter lordship, that agreement has been cancelled lordship. By power of attorney, it was agreement of sale was made, and this short date was sought for only because of the medical ground lordship, of particularly this petitioner lordship. So short date was called lordship. He had a lordship that prostate gland lordship is removed and a urinary bag was attached here lordship due to for infection. That lordship on last occasion prayer was made. So the short date was given for the case lordship. And otherwise, regarding that lordship, the nature of the allegation is civil in nature lordship. His allegation is there lordship to recover some money. That can be forum is there lordship to seek his relief lordship regarding the payment of money. And everything lordship I have pointed out lordship in the petition regarding the seizure of entire documents were seized lordship. That seizure, let me give one that is 20. That lordship on page 29 lordship annexed 3 lordship that everything will be available in the case that it should be lordship because the seizure was made. Original copies of general power of attorney, original copies deed of agreement for land sale, original copies of deed of cancellation lordship, that agreement sale and power of attorney was cancelled lordship, revocation of power of attorney, original copies of special power of attorney, original copies of deed of agreement, land lordship. All based on lordship agreement lordship. And some of the agreements were registered also lordship. That regarding that
So
he
why
can
case was filed against after cancellation of the document?
lordship, the allegation has been made that the amount was paid lordship. Now we have taken the money and we are not handing over them the state plot of land and we are supposed to sold it to other person lordship. That was the allegation lordship.
So now what about the money? You have taken already.
So that has been returned lordship. That will come in case there is lordship. Something lordship that what I says lordship that already. And regarding only thing is medical ground lordship. It was
the fact is that he, Aurobindo Rajvanshi, the petitioner, and item number 27.
Once he is a landowner of that plot of land lordship. He is a landowner. That present petition. That reflected in FIR also lordship.
He is a landowner, my lord. Basically, he entered into my lord, agreement for sale with 3 persons. One is Ibrahim Ali Bhuya, Farooq Ahmed and Safi Rahman. Ibrahim Ali is the my lord, petitioner in item number 56. He is one of the persons with whom agreement was made. And other 2 persons, Farooq and my lord, Safi are the my lord, informant in this case, my lord.
Farooq and?
Ibrahim Ali, Farooq and Safi Rahman. Farooq and Safi Rahman both are the informant in this case, my lord. Now,
I mean
earlier the agreement for
Farooq and Safi
and Ibrahim.
Subsequently, Ibrahim.
No. 3 persons. Ibrahim, Farooq and Safi. Subsequently, what happened, my lord, Farooq and Safi, without having any knowledge of Ibrahim, They sold the land to another person. Not the whole land. From the 1 bigger land, 1 katha, 5 lesser. Sold to another person, one Jitumani Gayon. Now there are dispute for non-payment of whole money. Disputes arise. Subsequently, the Aurobindo Rajbangshi again entered into an agreement and give power of attorney to the Ibrahim Ali Bhuyan. And in this meantime, yes, Agorpa register agreement no yes, but Ibrahim Ali, Ibrahim Ali's wife Purnima Bhuyan, no. Power of attorney was made in the name of wife of Ibrahim Ali, Purnima after Bhuyan. Subsequently it was made. But in the meantime, already there is an agreement, and without the knowledge of Ibrahim, other 2 persons sold it to another person. Because of that conflict, when these 2 persons, Farooq, Safir, and the new owner, they went to for the plot of land, they made some fencing and all this because of that some conflict. And this, as per the FIR, they said that the dagger down was taken, but no such scuffle was happened. It is as per the FIR, and as per the statement also, no such incident was happened. They stated that dagger down low ahi bhoy dekhaise. Now, fact is that the owner, Aurobindo Rajbangshi, he admitted that yes, earlier he has made an agreement. Without cancelling that agreement, again subsequent agreement was made, and power of attorney was given to Orunima Aftab, who is the made to Orunima Aftab Bhuyan. But the informant themselves, without having knowledge of the their partner, who is the Ibrahim Ali Bhuyan, they sold the 1 portion of the land to another person. So these are the conflict. Return of money, yes, but he has taken that, as per the statement of the Aurobindo Rajbangshi, he has stated that he 20 lakh to only stated that 20 lakh was taken. Other, he has not stated that. Only regarding 20 lakh he has stated. But the fact is that, yes, only after the agreement for sale, they have sold some portion of land to other person. They have taken 37 lakh, Farooq and all this. Some conflict are there. Otherwise, 22 days in the custody. And regarding this person, it's not very clear. Ibrahim Ali Bhuyan, he is also because of non-payment of part of the money to the partner, the whole incident happened.
Power of attorney was executed because of the
Yes.
wife of Ibrahim.
Yes.
Then why?
No,
he is
informant of Farooq and Safir, the other 2.
Okay.
And though it is in the FIR stated that thou low yahi, but these are no such incident.
that one first. Yeah. That. What? The hope. What?
Ibrahim Alif here. Lordship, we have Kamrup Metro. You will CGM Kamrup Metro. CGM. Much obliged, your Lordship. Much obliged. Much obliged.
Yes. See.
Similar to Lordship. I am the bona fide purchaser, Lordship. He is the landowner, Lordship.
You're Ibrahim Ali, huh?
Lordship, Ibrahim Ali Bhuya, Lordship. I am the bona fide purchaser, Lordship. Yeah, Hussain, Lordship.
When you were in custody?
22 days, Lordship.
From 19...
From 1904.
You also allowed.
Maple. Lordship, on instruction, I would like to withdraw this.
Okay, it will be disposed.
Okay.
Is it available?
Yes, CD available.
FIR is at page 10, Lordship. The allegation is that the informant sent a consignment of 425 bags of supari to Delhi, but after some time he lost contact with the driver. Thereafter, the truck with the supari was recovered in Bongaigaon, and on the basis of this FIR, Jogikupa PS case number 5324 was registered under section 392. These petitioners are not the name accused. They were arrested on petitioner number 1 on 25th March and petitioner number 2 on 28th March. Since 29 March, they are in judicial custody. And other accused has already been allowed to go on bail yesterday.
In this case, earlier to allowed one driver. The truck was taken from Jogikupa side to the Kamohi and subsequently unloaded in other truck. So earlier allowed one driver. This one person, Samar Ali is one of the labor who unloaded 110 bosta of supari to other truck. He is one of the labor. He said that I don't know whether it's stolen supari or not, but supari bag he unloaded. And one IO note, after investigation, I said that one Atwar Rahman and one Zainal Hussain. These are the main culprits. Those are not yet arrested. Who actually done that incident?
Who is Abu? Who is Abu?
Abu Hussain. Yes. Samar is the Abu Hussain also his statement. Yes, Abul also yes. He is involved in such type of Erekanat business, but he said that I have not done this. Actually, other persons told him that if he wants to take some bags, they can give him.
From where he?
Tamulor Garikhon Asadullah Khorloi Jai. Those supari 110 bags which was unloaded, that was deal with him. He want to buy that. Subsequently, he came to know that this is stolen supari. When police recovered from the possession of this Abu Hussain, 110 bags. That is there, from his possession it was recovered. But he said that Atware Mullogat Halsinaki. Atwar means main culprit. কি বেপাৰ কৰে মই নাজানো কিন্তু কি চুৰি কৰি আনা মাল বিক্ৰী কৰা বুলি মই জনা নাছিলো পিছত পুলিচে 110 bags out of whole 425 sold to him. He said that I don't know these are the stolen articles. That is the statement. Already 42 days. But main culprit Atwar not yet. IO not also stated. I found subsequent not of the IO. That's the main Atwar Rahman and one Zainal Hussain. Those are not yet arrested.
And also the truck and the supari, 425 bags supari already recovered and Zimma was given to the owner. Already given.
425 bags?
Yes.
From where?
From Bongaigaon.
Whole consignment was recovered.
It is recovered and Zimma was also given.
110 bags were recovered from this person, Abu Hussain. He said that it was sold to him. He don't know whether this is stolen or not. Length of detention, otherwise materials are there. But this Samar is one of the labor, he unloaded. Since 2019,
29. 42 days.
One is from 25 and another is 28. Petition number 1 is from 25th March. And petition number 2 from 28th March. Not Lord Salmara, Abhayapuri,
Not Kalmara.
not Salmara.
Yes, my lord. Not, is there not Kalmara?
Abhayapuri.
Actually, my lord, after that Kesari was called for, but after that he did not receive, my lord.
Yeah, Lordship, my friend has failed to produce the CD Lordship about 3-4 occasions, Lordship.
But
Lordship, my issue is also very simple, Lordship.
In the meantime, interim was
Yes,
granted.
yes, that is correct. So, Lordship,
on
your Lordship, please,
first of
Lordship,
March.
can you maybe also absolute the interim Lordship, because my implement is no is there, Lordship. Simple, Lordship, only due to apprehension, Lordship, I have come, Lordship. Otherwise, my name is also in the affair, and those persons, they have tried to issue save the God. They already have 4800, Lordship.
307, my lord, interim is there, my lord. One chance will be given.
307 is type.
Yes,
Our Sonapur, my lord, on 20, my lord.
try to produce the case that.
Madam,
yes, Lordship.
Your interest
Interim continue, Lordship. Hold on.
May I please, your Lordship? Okay, kindly have a look on the last direction, my lord. On 2nd of May, there is an order, my lord.
$31.
Yes,
My lord, yes, my lord, despite of last chance, of course, he did not receive.
Lordship will find the FIR at page 12, my lord.
so what is your
No, my lord,
there
twice, my lord, 1, 2, 3, 4, on 4 occasions we have sent signal. 2 Kejriwal call for my lord, 674 and 673.
in connection with this case, which is the required CD? 674 or 675?
Both the Kejriwal call for
No,
my lord.
The
FIR 674.
674.
My lord, no instruction also given by the my lord, IO, my lord. My lord, in such cases, we are also finding difficulty, my lord. Let the IO may stay, my lord. Otherwise, my lord, in some cases, my lord, tipster may go, my lord. Otherwise, my lord, no intimation also given, my lord. Why is it not given? It's urgent, we have written in the, my lord, on 3-5.
Basically, allegation of 333 and 353 was.
My lord. And my lord, already, my lord, that case, my lord, already trial court has released on bail, my lord. That is order available with me. So I am praying for today, it is on interim, my lord. Let them, they will produce, my lord, this is the order, my lord, that case, my lord. Bail case, absolute bail granted in the first FIR laws, where I was arrested, my lord. And in case number, my lord, 673, my lord, I have been granted absolute bail. If a lordship going to buy, this is the order, my lord. Initially interim granted, finally by this order, my lord, absolute bail
Against
granted.
you, there are two cases.
3 cases. This is the first case, my lord, 673, and present case is the second case, my lord.
Maybe, my lord, during this, my lord, election purpose also maybe, my lord.
Try maybe some protection, my lord, and let them case their my lord. Sorry.
Set the phone number 665 more and you by for non-production. Is that Mr. that on last week 5 of the what is that Maybe it will be under interpretation.
My lord, on 21st from Kasar.
I know people. Why? Why? Giving the I feel but if we are
Deep Lovelace, my lord.
Our 32 my lord Sanskrit submitted. CS number 21/2024, dated 31/3/24.
CS number
21/2024, dated 31/3/24 under section 326, 307, 506, 34. 506 and 34.
Are you going to include?
Yes, ma'am.
RDMS, RB, will be under interim presented on every report the planet report will be presented and presented will be under.
Yes, ma'am.
May I please, Your Lord. In this matter, my lord, LCR is called for.
LCR received,
my lord. My lord, FIR is at page number 20, my lord. May I read the vernacular one, my lord?
Otherwise,
Page number 24, my lord.
Charge-sheeted case, my lord. Petitioner
Charge-sheeted case
shown as absconder.
Shown as absconder, my lord. That was LCR is called for, my lord. May I read, my lord? Page number 24, my lord. সন্মানপূৰ্বক বিনীত নিবেদন এই যে ইংৰাজী 22/11/2022 তাৰিখে ৰাতিপুৱা 8 বজাত মোক নিম্নলিখিত পদকীয়াই মঙলদৈ বেগামুখৰ পৰা পকী ঢালাই কামৰ কথা কৈ অপহৰণ কৰি গুৱাহাটীৰ গড়চুকৰ ৰুম এটিত আবদ্ধ কৰি ৰাখে আৰু প্ৰায় 6 দিন ধৰি ধৰ্ষণ কাৰ্য চলায়। পাছত মোক পদকীয়াই আন বহিৰাজ্যত বিক্ৰী কৰাৰ চেষ্টা চলায় আৰু মোক চুৰিৰে হত্যাৰ চেষ্টাও কৰে। শেষত গুৱাহাটীৰ পৰা লৈ আহি দুমুনি চকীৰ বালিকুচি ইটাৰ ভাটালৈ লৈ আহে। তাতে হাতে ভৰিয়ে বান্ধি থোৱা ভাটাৰ প্ৰত্যক্ষদৰ্শী লোকে মোৰ ঘৰৰ পৰিয়ালক ফোন কৰি কয়, মোৰ ঘৰৰ পৰিয়ালে ভাটাৰ মালিকৰ পৰা উদ্ধাৰ কৰে। যোৱা ইংৰাজী 27/11/2022 তাৰিখে মোক উক্ত ভাটাৰ পৰা ৰাতি 12 মান বজাত উদ্ধাৰ কৰাৰ পাছত পদকীয়াই পলায়ন কৰে। দিছ ইজ দ্য FIR, my lord.
Now, you are for the
I am for the accused number 1, my lord, Gulab Ali. And accused number two accused person. Accused number 2 has surrendered, my lord, and thereafter he was granted bail by the Planet Court below, my lord. So FIR, as per the FIR, my lord, the victim was kidnapped on 22, my lord, and she was recovered on 27, my lord. And during this period, now, there are some discrepancies, my lord, so which create some doubt on the mind, my lord.
What is the stage of the case?
This date is the pre-committal stage, my lord, and next date is fixed on 21st of next month, my lord.
My lord, otherwise, my lord, he is shown as abscond. Let him appear before the trial court.
My lord,
Now the question is that you are the responder, but is there anything in the...
Yes, my lord, 164 statement, see clearly, I have tagged mark 164 statement of the victim, my lord. My lord, they in their petition, they stated only after after issuance of the warrant of arrest, they came to know that one case is going on against them, my lord. But before that also, my lord, they have submitted application. It is specifically mentioned on 5/10/20, both accused absent with steps. So they earlier they taken steps, my lord. So how they now can say that, my lord, they are not at all aware about the case?
My lord, fact is that during the course of investigations, I am not searched at all. Otherwise, I will file anticipatory bail before the court. And secondly, my lord, so far the FIR is concerned, it is clear, my lord, the victim or who is the informant, my lord, who is the informant, she always support her case, my lord. The question is at this present stage, my lord, because the case is a pre-committal stage, my lord. So at before the SDGM Mongoldoy, if we appeared, my lord, because of CRPC 209A, my lord, we may not be granted bail, my lord. In this regard, my lord, this honorable court recently decided a similar case, my lord. If your lordship please, my lord, I have a copy of that order, my lord, wherein also this honorable court only go to the facts that whether custodial detention or the detention of the the petitioner during the trial is necessary or not, my lord. And even the accused number 2, who was granted bail by the trial court below, by the session court, my lord, in that order it is also reflected that during the trial custodial detention of that accused is not necessary, my lord. So, keeping in view of all these facts, my lord, because appearance of the petitioner will facilitate the, my lord, investigation, and there are part, my lord, so far the FIR is concerned, my lord, there are various discrepancies. The victim girl was recovered on the night of 27 at 12 noon, my lord. But the FIR was lost on the next day at 5 p.m., my lord. And even it is stated in the FIR that the girl was spotted by the some persons and apprised the same to the family member of the victim, my lord. But the family member of the victim never come to the Itavata with police, my lord. It is reflected in the FIR. So there are something, my lord, in the FIR, my lord. And so far the allegations and the charge sheet and the evidence is concerned, I will face the trial. I will defend myself, my lord. So at this instant, my humble submission is that, my lord, at this instant, my lord, he may be allowed to go on bail so that he can appear and defend his case, my lord. If your lordship please, my lord, I have an order recently passed by this honorable court.
Sir.
M.A. Hussain.
the dispute is accepted. And right. No, right. Right. Okay. And it- as I said, not it's the chart and from out the first chart someone was up and not the night board. Okay. What that that and but that also 8,000 but and this for that what your summons were already issued, no?
Warrant of arrest issued, man.
Yes, ma'am. Warrant of arrest issued, ma'am.
So, some protection may be given, my lord.
Okay, your NBW is prevented till your
It's warrant of arrest, NBW, no, my lord. Warrant of arrest issued, non-below.
Yes, non-below. Warrant of arrest, non-below.
Some protection may be given on till
yes,
then.
I have protection is there till 10 days to appear. And till 10 days is the execution of non-payable warrant or warrant of
And then,
state or suspended.
I said then what, my lord, in the pre-committal stage. Pre-committal stage. Okay.
Please, Your Lordship. 430 replication of. Lordship will find the FIR at page 21, Lordship. The FIR was lodged on 19/6/2012. Here, Lordship, the accused is shown as absconder in the charge sheet, and then subsequently NBW and PNA was issued against two petitioners. The petitioners before Your Lordship are brothers. There is a typographical error in the name of the father of the petitioner number 1. That is, I wrote it as Sonaram Bey, which has to be Sarmin Bey. Now, Your Lordship may kindly see the FIR at page 21. On 19/6/2012, page 21 is the vernacular. On 19/6/2012, the FIR was lodged. Lordship may kindly see the total number of accused. 8 persons were arraigned as an accused. Here, petitioner accused number 3, Viren Bey, and accused number 7, Mongol Bey, are before Your Lordship. Lordship may kindly see the address of the accused persons. Khorbo Khang, Langhut Inghi Gaon, Thana Kharani, Zila Karbi Anglong. Thereafter, Lordship, initially the case was registered under 458/365, and then investigation was started. And on 31/12/2019, after 7 years, Lordship, The charge sheet was filed against all the 7 persons who were arraigned as an accused in the FIR, showing the present petitioners as absconder, including one another accused. He is not before your lordship.
FIR was closed on 19/6
FIR on my lord 19/6/2012.
Charge sheet was submitted on 31/12/2019. In the charge sheet also, my address, the address of the petitioners are shown as Langhut Inghi Gaon, PS Khairani District West Karbi Anglong, District West Karbi Anglong.
And all the accused petitioners are from same village.
From the same village, they are brothers, actually, lordship. They are brothers from, and they are resident of a different village, not in the village mentioned in the FIR as well as in the charge sheet.
They are resident of
Different village. Police never conducted any search in their residence as well as in their village. I have annexed documents in support of my claim, lordship. Thereafter, lordship, on 35 of the submission of the charge sheet, on 35/2022, cognizance was taken by the learned JMFC, fixing 22/6/2022. At page 27, your lordship will find the summons issued to the petitioners. These summons we have not received. We collected it from the court, lordship. The address mentioned in the summons, your lordship will find, kindly see, village Langhut Inghi Gaon, page 27 and 28. Biren Bey, son of Sarmen Bey, village Langhut Inghi Gaon. This is the address mentioned in the FIR as well as in the charge sheet, and police conducted investigation, went to these villages. Thereafter, lordship, on 30.
You are not the resident of this.
Yes, lordship. I have annexed my voter list. I have filed an additional affidavit of 2010, showing that I am a resident of a Norong Ronghang Gaon, not Langhut Inghi Gaon. So I have placed there also, lordship. On 31/23, BW was issued. Since no report on the summons issued to the petitioners were received, on 31/23, BW was issued. Page 33, and NBW as well as PNA was issued. And NBW was issued in respect of petitioner number 2, and NBW and PNA was issued in respect of petitioner number 1. Now at page 36, lordship, I have annexed the voter ID which was issued in 2013, 1/10/2013, stating that the village is Norong Ronghang Gaon, PS Khairani. The police station is same, but the address of the village is different. I do not know that there was a case pending against me. Police never conducted any search in my house as well as
Other accused persons or other 6 numbers of accused which were added to the.
some of the accused persons are appearing before the court below.
Are they brothers?
No.
You two are brothers.
Yes, lordship. Only these petitioners. In fact, I do not know those other accused persons. They are from a different village. And in my additional affidavit also, lordship, at page 44, I have annexed the voter list of 2010. Serial number 331 to 337. All the family members of the petitioners are enrolled in the voter list of 2010. This says that they are resident of Norong Ronghang Gaon. So, lordship, I am not a resident of Langhut Inghi Gaon. This is a case where, lordship, police, the complainant mentioned an address, police went to that address, whereas I am not the resident of that address. And how could I be shown as absconder in a case where police...
Now how can you come to know?
Lordship, now when PNA is issued, probably this is sent to the SP, West Karbi Anglong. Now the entire police of West Karbi Anglong is behind me, lordship, looking for me.
My lord, after 12 years now, they have approached before this court by stating that those address mentioned in the FIR, mentioned in the search sheet, is not my original address, and now stating a different address. That is, your lordship, I have flag marked the statement of some of the villagers, and he has also stated the police never charged these accused persons. Your lordship, from the statement of the villagers, it is very clear after this offence, my lord, they changed their original address, my lord. Now after 12 years, they have come by stating that.
to his address.
ভোটাৰ লিষ্টখন ভেৰিফাই কৰিব লাগিব
In that case, verify for.
days of that voter list also.
These villagers probably are from Langhud Inghi not from Norong
Kheroni, is specifically mentioned.
They might have stated something against these petitioners.
And there are other records also, police charged them.
They do not know whether they are involved in this case, but they have
regarding their address, my lord, because he is submitting
other village for to avoid the police.
Yes, my lord, specifically stated.
Actually, the incident occurred in 2012. I have placed the voter list of 2010, which specifically says that I am not the residence of the place where police conducted search, and I am not the residence of the addresses mentioned in the charge sheet as well as in the summons as well as in the FIR.
Now, my lord, he can
How
do
could
one
I
thing
know?
by placing this voter list. He can file an appropriate application before the trial court.
Lordship, that
trial
is the
court
problem.
will consider, my lord, in accordance.
That
with
is the
law.
problem, Lordship. It is a 302 case, Lordship. The moment I file an application, since I was shown as absconder, trial court JMFC cannot grant me bail, since there is a lifetime or death penalty is there, the punishment. So ultimately, the moment I appear, the trial court has to send me behind bar.
How they are added in the FIR. But FIR not add an age.
Langhod Inghi Gaon. That is clear in summon, Lordship, page number 27, Lordship. Page number 27. Norong Ronghangao.
Norong search for it as if not down Ika rather than wrong wrong it but it would of wrong that demo thereafter went back. Of that report that I and some of the commissioner I put on various street and but effort and that all the security officer it was submitted from the recorded by I it said that after the edit and on for effort for that happened. Incident occurred on and the games of which are out out and thus people not intent of the at the platform. Scan of the page report from the record that see that the internet could be at separate and comments on the and after issuing summons that the were against them. But PW were also as separate report property of but it and an effort right but for five yes but one help not support the incentive and more summonses and empire but it was the not what was it not not but yet no it not cannot be up. I hear that I you're directed to appear till 10 days. Your admitted and DNA.
But
And I made all the observation there
Yes,
as
okay.
to how you did not receive any sample as per your submission. Submission made by the water.
But the difficulty is that, Lordship, the moment I appeared, though the NBW is recalled, and the trial court cannot grant me bail because it is JMFC, and case is exclusively triable.
Whatever.
Lordship. Obliged, Lordship.
May please, Your Lordship. 35 charge sheet submitted. May please, Your Lordship. In this case, charge sheet submitted. Petitions are intended. P-New. CS number 124/24 dated 25/4/24.
within oblige.
My lord, 36 case diary not received, my
My
lord.
lord, kindly have a look on the 3rd of May. Some direction passed by this honorable court.
It is certainly.
I think pass number 10.
Wait for one.
With the fifth occasion, and last occasion, this honorable court has recorded certain observation, my lord. My lord, my prayer, my lord, as per the FIR, my lord, since this honorable court is directed, my lord, if they fail to produce the CD as today, my lord, so my prayer may be considered, and my humble prayer, my lord, is the 5th occasion, my lord, already, my lord,
Of order happened.
as per the my lord, kindly have a look in the FIR, my lord. My lord, already, my lord, they conducted inquiry, final report submitted as per the inquiry at the FIR, my lord. Since, my lord, this is a case of, my lord, is a documents, my lord. All the document they have verified, conducted inquiry, found certain misrepresented certain things, my lord. So, my at this stage, my lord, before
Misappropriation of more than 1 crore.
That is
my
true.
lord.
What is case diary then?
Yes, my lord.
What is the intimation? Have you received any intimation? No.
No, my
It is for the election purpose.
maybe, my lord.
and even for personal direction is also recorded, my lord. If they fail to produce, there is a order, my lord. The personal appearance of the IO. Why he have not sent it? It's the 5th occasion, my lord.
36.
How many signatures you have sent?
My lord, 1, 2, 4, 5 times, my lord. And you get- All right.
Percent to order
3-5.
But the amount of money. It can be
On my lord, 28 5.
Too long. But some sort of 28.
21 5, my lord. Well, a copy of this order may be kindly served.
Of the order.
So,
My only humble submission before this court, on 21st, in case if they fail, my lord, my bail period may be considered, my lord. Otherwise, my lord, I am for the last the 5th occasion, actually be the 6th occasion. My lord. Deep love, bless me, lord.
37 fact sheet submitted, my lord.
Yes, that's the number.
76/24, dated 29/3/24.
Are you going to institute earlier?
No, Lord. I will approach Lordship. Till then, some protection may be given.
You are not protected now. Cannot be Mr. Rana. I am Rana. You are Mr. Rana.
M. Rana.
Hard.
Kamal.
May it please, oh Lord, Shimala PRS bill application FIR is at page 10. There are three accused, my lord. Imran Ali, Firoz Ali, and Pulima Baby. My lord, I am number 2 and 3. The father-in-law and the mother-in-law. My the son got married and he was staying separately, man. The son is arrested. The husband is arrested. The father-in-law and the mother-in-law is before your lordship. Mother was given an interim protection.
Yes, my lord, CD available, my lord. Statement of the mother is available. My lord, she given the statement. Though they are residing in the same house, but the room is another room, my lord. But fact is that, my lord, those CD available, the postmortem report and the FSL, Viscera was sent for FSL. Those two are not. The postmortem report is also not available. Only the inquest is available, my lord. As per the statement of the mother, at that time some altercation was there, the husband and wife, and subsequently husband went out to the market. After half an hour, when he returned to the room, he shouted that he commits suicide. But at that moment, no one was there. So postmortem report is very essential.
So the husband is already arrested. The
husband arrested.
Your number two will be extended and try to contact the IO over telephone or we can get
if your lordship,
at least PM
your lordship may consider one aspect, because as per the present position of the case diary, the father-in-law may be given an interim, he will give his statement, my lord. The son is already arrested. And the statement of the father-in-law may be, he's an old man, my lord. They used to stay in a separate room, my lord. Father may be given an interim and the statement may be recorded, my lord. The mother has already given the statement.
Otherwise, whether he is in the home at that time, that was also not mentioned. But interim I didn't say anything, my lord. But for final disposal, my lord,
there it is the sake of objection they are giving.
No, I am not giving the objection.
Please, let me finish. Then you say, let me finish, then don't come in between. I am saying, my lord, he is the father who is an aged man. They are saying in their case diary he is living in a separate room. The husband and the wife, they had a quarrel. And my lord, she committed suicide. The husband is arrested. My lord, why the father-in-law is the aged man, my lord? The mother-in-law has given his statement. And they could not say till now from the case diary whether the father-in-law was present or not.
With all respect to Senior Malat, I have stated that regarding interim statutory, but for final disposal, I said an aged person is 45 years. Because of that, Malat, Senior has not had. I have already respected Malat.
He cannot be considered as a aged person. 45 years cannot be considered at all as aged person.
Whatever it is, Malat, he is a.
I have said,
he is the father-in-law.
For final disposal, PM is required. Regarding interim, I have nothing said anything, Malat. Always, Malat.
there. I don't. Okay, your one is also done. But here returned it.
My lord, on 28th of May.
Obliged, sir.
After I have 57.
41 my lord, CP notice.
Third time probably it will be fourth time probably.
Third time. Twice we have sent signal.
Otherwise, we generally receive this case diary.
Yes, yes, I understand. But
For the election purpose, maybe
Yes,
maybe
yes,
one.
Karimganj, Kasar, my lord, long distance, my lord, and
poor petitioner, we are not on interim bail. FIR, all those sections are there, 364A. He was held up and allowed to go. How 364A will come? It does not
If
come.
it happen allowed to go, if this is the position, then he will not be arrested.
No, my lord, only thing, my lord, can you see whether it's a case of
Just
364A?
one chance may be given to the IO, let us see.
A short date may be given, my lord. Long time already gone, my lord.
From where it has come.
Badarpur.
Badarpur, Karimganj, my lord.
No problem nowadays, my lord. The road is open now. It was blocked, it is open now. I'm told.
22nd, my lord.
Can it be a little bit short, my lord?
20, my lord, 20. 20.
20. 20.
All right.
43 also, my lord, CD notice.
43 short date may be given, my lord. This is not an entry, my lord. Dhubri from Dhubri.
21st, my lord.
So, from Dhubri. Dhubri.
My lord, 20, my lord, 20.
Lordship, possible for timing, HRA Chaudhary sir will appear, you know. He's coming on the way.
$57.
57 also he will
My
appear.
lord, the scan copies have not received.
57 is
57 also HRA Chaudhary will appear.
Scan 57.
44.
I'm sorry.
44.
44,
You are on 44 and 57 both.
Yes.
Lordship.
57 you are there.
That is another case, Lord.
No, yes.
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 Yes. 44, matter 394 is the offense alleged. 394. Your lordship will find page 9. I checked your lordship to a vernacular portion, that will be my name, page 14. Page 14.
Yes.
That is more clear, my lord. Your lordship, for 4 persons named in the FIR.
Yes.
I am number 2, my lord. 2 is before lordship. So now, allegation is my lord that on 10 th ৰাতি ট্ৰেইন ইমান সন্ধিয়া ট্ৰেইনৰ পৰা পুৱা ইমান বজাত 4 কেজি গ্ৰাম আগলৈ আজি পুৱা 7মান বজাত হোজাই ৰেল ষ্টেচন আহি নমাৰ লগে লগে পূৰ্বৰ পৰা পৰিকল্পিতভাৱে ৰৈ থকা আছামীগণে মহৰ বাট আগচি ধৰে আৰু আছামীগণে নিজক RPF অফিচাৰ বুলি ভুৱা পৰিচয় প্ৰদান কৰি মোৰ হাতৰ পৰা আগৰ ট্ৰেইন বেগটো ট্ৰলি বেগটো কাঢ়ি লৈ 1 আৰু 2 নম্বৰ আছামীক সমজাই দি এডাল লোহাৰ ৰডেৰে মোক পিঠত ও কঁকালত প্ৰচণ্ড জোৰে কৰাই গুৰুতৰভাৱে মোক অফিচত নাম অজ্ঞাত আন 2জন আছামীৰ সহযোগত 1 আৰু 4 নম্বৰ আছামীক সমজাই দিয়ে ও হোজাই RPF অফিচলৈ জমা কৰিব বুলি লৈ যায়। মই হোজাই ৰেলৱে ষ্টেচনত যোৱাৰ তানাত বাৰ্তা বিভাগ মহোদয়ে 2 আৰু 3 নম্বৰ আছামীক কোনো আৰক্ষী কৰ্মকৰ্তা নহয় বুলি মোক অৱগত কৰায় কেৱল 1 নম্বৰ আছামী আৰক্ষীৰ লোক হয় বুলি কয়। নম্বৰ 1 1 নম্বৰ আছামী বাকী আছামীৰ লগত লৈ পূৰ্বে পৰিকল্পিতভাৱে 2 আৰু 3 নম্বৰ আছামী আৰক্ষী লোক বুলি পৰিচয় দি মোৰ লগত প্ৰতাৰণা কৰি মোৰ প্ৰায় 7,50,000 টকা আগৰকাৰী লৈ যায়। 1 নম্বৰ 2 নম্বৰ আছামীয়ে মোৰ ৰেলপথত থকা অৱস্থাত ফোনযোগে মই হোজাই আহি পোৱাৰ বিষয়ে সোধাত মই সকল বিষয়ত যাওঁ। So now basic question, my lord, at the railway station, it happened. In the railway station, your lordship will find CC camera is there. Everything is there. My special case is that sofa number 2 is concerned. He is a driver of a vehicle. Normally, he might have, the railway passenger, he normally take as a passenger. So his case that on that day he was not present. And moreover, my lord, CC camera was there. And if there is anything, whether he was seen in the camera or not. So, moreover, the whole question, allegation is against number 1, who is a police official. He was arrested, already released on bail. 439. Now, my case is, that my first case is I was not present. And second case is that, my lord, that if there is anything, that will be reflected in the CCTV footage. My special case is denial of my presence, my lord. I leave it.
Lordship, I have
You produce your coming.
his involvement is there, Lordship. He has taken the goods and taken by his car, Lordship. He was very much there.
Footage is there.
Footage is there, accused, alleged. Footage is there.
No, P94 also, my lord. In that case, P94 comes on now. That will be a lot. Number statement is accused number 1.
First they were granted bail in the district court, Lordship, then it was again rejected, Lordship.
That is, we have an action. P94 is attracted on no point. Supposing my lord is there. P94 so far as this present petitioner is concerned. Or it will come P19. The registered nurse is P19, my lord, or 419 and my lord P94. Now, P90
will come for one, I think.
that
Yes, 390.
P94 is not coming, my lord. Is not attracted so far the present. If it is found, I do not know what is there in the CD, my lord. And things recovered from home, I do not know whether recovered or not.
I recover that.
On number
They
one.
have changed the articles.
Uh,
They have changed that.
Rather, on rather, both, both. Like, the but we had prior but your petition stands rejected.
One.
What?
No petitioner. Your worship is asking about petitioner.
So one petition.
Your one is Raju Das?
Raju Das.
Yes, this is rejected. Other petitioner also?
No, not
No.
only.
No, only one petition.
Only one.
In 56 also you are there?
No, I am 57.
Sorry,
57. Yes, sir. Objection.
Bora is also 50. So, for repeat for response number 2.
Informant
No,
point.
for the informant.
It is a case between the two relatives, my lord. Informant is the, my lord, your loss will find there are four, Abdul Matin, name. Kimanjano naam ase? Your loss will find here are total 4 petitioners. If I have some naam ase nani. Yes. Sober naam nahi. Yes. My lord, kindly say page 2, my lord. 4 persons. I'm just, my lord, taking the identification of 4 persons. Number 4 is, my lord, is father of number 2 and 3.
Number 4 is father of 2 and 3.
2 and 3. And number 1 is brother-in-law of number 4. And his wife, brother, mine. These 4 persons will worship. Now, informant is the wife of accused number 4's brother's wife, mine. Informant is wife of accused number 4's younger brother. Brother's wife. Accused number 4's brother's wife.
The informant is sister-in-law?
Yes, sister-in-law of the number 4, mine. Number 4. Accused number 4. Now, some property dispute are there, my lord. Now, your loss will find the SMS. Box on page 18, your loss can say Barnacula person. English. Yes. সম্মানপূৰ্বক বিনত নিবেদন এই যে অপৰপক্ষ মগ একে ওচৰা বৰীয়া লোক হয় sorry page 11 no my 2 FIR cross FIR is there, my so FIR where I am asking bail in my page 21 page 21 page 20 page 21 now Barnacular is page 29 your lost page 29 page 29 to ভাল লিখা আছে না well he will read that will better legible এই যে page 29 ko assamese পরিষ্কার আছে না পাওয়া না যায়
মোৰ সন্মানপূৰ্বক বিনীত নিবেদন এই যে অপপক্ষ মোৰ একে ওচৰ চুবুৰীয়া লোক হয় যোৱাকালি মোৰ দাদা 6 মান বজাত মোৰ ঘৰলৈ 8 মান বজাত মোৰ ঘৰলৈ বজাৰ কৰি আহি মোক নিবলৈ আহে মই কলো তই অকলে যাব নালাগে মই তোৰ লগত তহতৰ ঘৰলৈ যাও মই অহা ৰাস্তাত এটা কুকুৰ বহি আছিল কুকুৰটোৱে আমাক দেখি ভুকিব ধৰে তেতিয়া মোৰ দাদাই কলে মই চুৰ নহয় চুৰকে ভুকিব লাগে I don't might remember this case yes মোৰ দাদাই কথা শুনি 2 নম্বৰ অপপক্ষই আমাৰ পিছত আহি কাক চুৰ কথা কৈছ বুলি মাৰপিট কৰে তাৰ পিছত ঘৰৰ 3জন অপপক্ষই মাৰপিট কৰি থকা অৱস্থাত 1 নম্বৰ অপপক্ষই চোকা অস্ত্ৰ লৈ মোৰ চকুৰ আগতে লাইটৰ পোহৰত মাথাত হাত গাত কাটি জখম কৰি অপপক্ষই এঘৰ মানুহৰ ঘৰত পলাই থাকি থাকে
তাকে।
এতিয়া মোৰ দাদাক উত্তৰ লখিমপুৰ চিকিৎসা ভাল কৰিব নোৱাৰি ডিব্ৰুগড়লৈ ডাক্তৰে ৰেফাৰ কৰে তাৰ কাৰণে মই গোচৰ দিয়া পলম হয়
So this is the FIR where I am here. Now madam, our FIR can be seen, madam. Page 11. This is in first point of time. Vernacular is, so that English I think it is no problem, madam. That's the right translation, madam. 11. Here, wife of number 1. Wife of number 1 is the informant. You also can see Najma Beg Jahan, wife of Farooq Jahan. Farooq Jahan is the petition number 1. You also got it. Page 11. Complainant begs to here, my lord Abdul Matin, son of sons. Complainant begs to state that today evening at about 8:30 p.m., opposite party being intoxicated with wine came and without any reason assaulted my nephew Muhammad Safi Rahman. Safi Rahman called my husband about telephone. We went, Safi Rahman causing injuries to the nose and head. While Safi Rahman called my husband about telephone. Safi Rahman is my petition number 2. While Safi Rahman called my husband over phone, we went to the place of occurrence. Opposite party instantly pelted with a boulder to the chest of my husband, causing serious injury to him. Opposite party ran away to his house and came back with dao in order to assault my husband, and while doing so, he sustained severe injuries by dao which he was carrying. Having intoxicated with the wine, the opposite party could not be able to control himself. It is to be mentioned that the opposite party is an employee of police department under the government of Assam. After the occurrence, we went to the PO and the police took my husband and Safi Rahman to Lakhimpur Medical College Hospital for treatment. Presently, both are under treatment. So it was registered under section 325. Now charge sheet already filed in this case, man. Under section 323. Charge sheet already filed, no? And 341. Case taken, both the cases were called for violence, but in this case, I have been told.
Charge submitted, scan copy also come.
Yes.
Cross case?
Yes. So this case, your lordship will find this is not the PH case number 2424. And the present one is 25. So earlier point of time, this was filed. Now, admittedly, might some occurrence took place. It is not in dispute, my lord. Now the question, my lord, whether both the parties suffered injuries. Relation, my lord. Whether, my lord, only 326, my lord, both the party, I also suffered, my lord, I have given also, my lord, she filed objection, we also filed reply to that also. So both the parties might have suffered injuries, but the only question, my lord, whether custodial integration is required or not, my lord. This is the only thing. A mutual, my lord, because misunderstanding, my lord. Dog was barking, my lord. I told the dog, why you are barking to me? You bark to the thief. Accused number 2, my friend number 2, he thought that he was referring that thief to him, my lord. So this is how this misunderstanding took place, my lord. And this has led to the incident. So in that case, my lord, whether custodial, I am only on that, my lord, custodial integration is required or not, my lord. On view of the court cases admitted. Injuries are there, but I am not disputing injuries, both the parties.
Yes, my lord. That cross case, my lord, that is registered on 5-2.
Yeah.
5-24.
Yeah.
But that is in that case, charge sheet submitted under 323, 341. And injury report I have tagmarked. Farooq and Safiur, both have simple injury. Simple injury. Now in the present case, they itself in the FIR stated that due to treatment, they are late in lodging the FIR. FIR is lodged on 6/2, next day. And there is simple injury, they went first to lodge the FIR, my lord. That is one of the issues.
We fight.
Now, yes. Now, my lord, as per the injury report, my lord, first, this North Lakhimpur Hospital, my lord, there only sharp weapon and fresh injury was there. 3 fresh injury in the scalp. It was dated and referred to AMCH or GMCH. Now report from the AMC, Sasha Medical College, Dibrugarh, my lord. Its nature of injury is grievous, but sharp weapon, my lord. 3 injury, one is, my lord, 3 inch, 1 is into 0.5 centimeter. One is, my lord, 12 centimeter in the parietal region, my lord, 12 centimeter. And one is 5 centimeter approximately. 3 cut injury by sharp weapon, my lord. And other injury, other also, my lord, beaten, my lord, that, my lord, by. But basically the head injury is, my lord, 12 centimeter. All by, my lord, this grievous and by sharp. So now, as per the statement of the, my lord, injured himself. I am coming to statement of the wife also. মোৰ নাম আব্দুল মতিন, মই আমিতো ৰহমানৰ ঘৰত মোৰ পত্নী থাকো। মোৰ ভাড়া ঘৰত অলপ আগতে ভণ্টি থাকে, ভণ্টিৰ বজাৰ প্ৰায় বজাৰ কৰি দিওঁ। আনদিনাৰ দৰে আজি 5/2/24 তাৰিখে প্ৰায় ৰাতি 8টা বজাত মই ভণ্টিক বজাৰ দিবলৈ যাওঁ। মই ভণ্টিক বজাৰ দি উঠি ভণ্টি মোৰ ঘৰলৈ একেলগে দুইজন আহি থাকো। ভণ্টি আৰু মোৰ ঘৰলৈ আহি থাকোঁতে এটা কুকুৰে ভুকে, তেতিয়া মই কওঁ মই চোৰ নহয়, চোৰকে ভুকিব লাগে। এই কথাত ছফিউৰ ৰহমান শুনা পাই মোক পিছফালৰ পৰা ঘোচা মাৰে। ছফিউৰ ৰহমান ইজ দ্য পিটিশ্যনাৰ নম্বৰ 2 অপুৰ ঘোচা মাৰে আৰু মোৰ জীৱন ৰক্ষাৰ কাৰণে ময়ো তেওঁক এটা ঘোচা মাৰো। তাৰ পিছত অমিত ৰহমান ইজ পিটিশ্যন নম্বৰ 3, মতিত ৰহমান একিউজ নম্বৰ 4 মোক ধৰি মাৰপিট কৰিবলৈ আহে। মোৰ মাথা মুখমণ্ডলৰ পৰা তেজ ওলাই আহে। মোৰ প্ৰাণ ৰক্ষাৰ কাৰণে মন্টু আহমেদৰ ঘৰলৈকে পলাই যাওঁ। মন্টু আহমেদে মোক মেডিকেললৈ যোৱাৰ কথা কয়। সেই সময়ত ফাৰুক জাহান, অমিত ৰহমান, মতিত ৰহমান। ফাৰুক জাহান ইজ দ্য একিউজ নম্বৰ 1, ছফিউৰ ৰহমান একিউজ নম্বৰ 2, petition number 2, Amir Rahman, and all are present, my lord. All have beaten. Now, statement of the wife of the, my lord, victim, my lord. Others, my lord, first part is same, my lord.
Informant.
Yes, informant. এই সময়তে অপয়া এই কথা বুজি মোৰ স্বামীয়ে আত্মৰক্ষাৰ কাৰণে অপুক ঘোচা মাৰে। দিছ পাৰ্ট ইজ চিমিলাৰ। অপুক ঘোচা মাৰে। অপু মিনছ মানে দিছ অপু এই পিটিশ্যন নম্বৰ 2, ছফিউৰ ৰহমান ইজ দ্য অপু। অপুৱে ঘটনাৰ পৰা গুচি যায়। সেই সময়তে ছফিউৰ ৰহমান, আমিৰ ৰহমান, মতিউৰ ৰহমানে আহি হাতত দা লাঠি লৈ মোৰ স্বামীক মাৰপিট কৰিবলৈ আহে। সিহঁতে মোৰ স্বামীক পকা বেৰত হেঁচা মাৰি ধৰে। মিল্টনে মোৰ স্বামীক দাৰে এঘাপ মাৰি দিয়ে। মিল্টন ইজ ফাৰুক আহমেদ মাৰি দিয়ে। তেতিয়া মোৰ মানুহটোৱে কৈছিল তোমালোকক মই সহায় কৰিছিলো, মোক কিয় মানিছা? তেতিয়া মিল্টনে আকৌ এঘাপ মাৰে। মোৰ স্বামীৰ হাততো জখম পায়, মূৰতো জখম পায়। পিছত আমিনুৰ ৰহমানে মোৰ স্বামীক লাঠিৰে পেটত আৰু বুকুত আকৌ মাৰে। স্বামীয়ে প্ৰাণ ৰক্ষা কৰি ওচৰৰ মানুহ এঘৰত যাই প্ৰাণ ৰক্ষা কৰে। So this is the actual fact, and sharp weapon is used and not if by provocation. Once hit thrice. Head injury is I have described may see the 12 centimeter long, one is 5 centimeter, one is 3.1, and these are the injury
Page 55 is visiting. Page 55 of my affidavit.
Affidavit from my God.
Page 55 will reflect all.
And the cross case, though it is lodged in on the same day of the incident, but these are simple injury, and succeeded under section 323, 341. Injury put I take my mother. And so badly beaten, cut injury, 3 cut injury, 55. So
he out of self-defense has to kick, and in that course, injuries. He's a
Injuries
police
seem-
personnel. For that reason, he. I don't remember this.
otherwise, my lord, anticipatory will, my lord, I am strong objection against all, my lord. Farooq, Safir and Farooq, Safir, Aminur, all are, my lord. Motir also present, though 58. But 1, 2 and 3 are specific.
50, my lord, 4, if is number 4, is the father of number 2 and 3. A specific allegation against him, my lord, against 2, my lord. It is number 2, basically.
1, 2.
Anyway, my question of all family members, man, Moon brother's wife. Yesterday admitted I am not disputing the injury part, man. Family members, now I think it is settled. My lord, they let them live peacefully, my lord, instead of going. So
Think that there is settlement.
wife's ultimately.
On that occasion, there was a submission that was self-implicated injury, not by her, but Junior Elsa was not there. The doctor was a what case to self-injury, not sex.
No, I'm not saying so. I am
No,
not.
I said
I am not disputing that part, my lord. I am just let them live simply, my lord, peacefully. Let her also influence them, my lord.
Some passerby, some provocation or something. Some person, if someone is behaving in this way, then and he is a defense personnel. Actually, for that reason, he is safe. Had it been any ABC, anyone, no one would have been safe in this injury. He is a physically fit person of police, and even he has got some awards and all those things with regard to physical fitness. That is the only reason he is. My lord has seen the injury. It's not a normal injury. 3 skull injuries, 1 right hand, 4 injuries, and whole body with I don't not to consider the application. With due respect to my opinion.
No matter, I think she may consider about 4, my lord, number 4. Senior 58 years, but he is a government employee also, my lord. He is government employee. With a 4, my lord. Okay. SP allegation is, my lord, 2, but 1 it may come. About 4, my lord, I am only on that 4 may be considered by your lordship, my lord. 58 is government employee also, my lord. Only that part I lift your lordship, my lord. An independent witness has not attributed to him to the extent others have been attributed.
I have objection against all, my lord.
ठीक है सर, फोर तो दीदी है क्या? फोर में भी consider, but I also consider my four में भी. Others.
Injuries were also 4 injuries. 3 skull injuries. But because 3 skull injuries, 4 still.
Hand.
Backing, so total injuries in that way also. 1 is in the right hand, and the other.
What's the part played by Mr. Motiur Rahman?
Yes.
Airport
No
number 4.
specific.
He was also there.
All forward, yes. All forward, yes, my lord. So at
No,
this
their
stage,
presence was
there.
there.
What injury cannot be stated at this stage of considering a bill? Because, my lord, if 34 comes into play,
Because of age and because of their own relation, my lord, and government employee also, my lord. That I lift your lordship, my lord. Yes,
for now, if someone passed by also, it's over.
yeah, no, that my lord. I am not disputing that part, my lord. Point of law. But I am only on that kind of 4, maybe my lord, 58 years or 59.
मतलब केवल सफीर रहमान अमीर रहमान মতিউৰ ৰহমানে হাতত দা লছিলে মাৰপিট কৰিবলৈ আহে আৰু সিহঁতে মোৰ স্বামীক সিহঁতে মানে অলৱেজ ইমপ্লিকেটেড
সিহঁতে my lord. বহা দেখা যায়. তোমাৰ দেশৰ
log of one log was party. But as per you, who sustained injury?
Hello?
From your side, who
Farooq
sustained
and Safiur.
Yes.
Safiur.
Yes, Sophie Umar. I am saying about Sophie Umar. Number 3 is the main person, my lord,
No,
from
no,
the
no,
FIR.
I'm not on that. Who sustained injury from your side?
1 and 2.
Oh, 1 and 2.
1 and 2. Both
Farooq and Safiur.
Yes.
I have played
I was
one
NX lordship. One
NX.
of the photographs lordship 59.
That is there on the record, man.
Reading in his nose lordship.
One. Five of five. Four. Six. Four brother. Not talking with what out. One. Not But the way but you filed your objection. You have filed your
My lord, I have filed it on one. It is from page number my lord 39. It's not 39.
We have filed a reply to that.
Yes.
39. And
record out if there any question. That he had and after your petition stands rejected.
Hello?
Your petition stands rejected.
All.
For all.
Obliged, please.
May I please, Lord? I am for the respondent, Your Lordship. The petitioner has filed a case, transfer petition. The prime ground on which they have filed this case, Your Lordship, is that the petitioner has an old age, bedridden
Let
mother.
the petitioner come. Otherwise, it is a transfer matter.
Yes, Your Lord.
The other side is absent, so they may not be interested in this whether deputy. Was there any? Is there any stay? No.
There is a stay, Your Lord.
Is the order of stay is there?
Yes, Your Lord. Finally, Indian may vacate, Your Lordship.
The stay order is there.
Yes, Your Lord.
See for one thing. The Mr. R.
I am for appearing for R. Sharma, Your Lordship. A. Chaudhary.
A.H. Chaudhary.
Yes.
R. Yeah. Mr. R. passing it, let us see if next day they remain absent, then it may be vacant.
Yes, sure. After 2 weeks.
2 weeks. After
today. Right, your lord.
May I please, your lordship. 482 application, lordship. Challenging the order dated 22/11/22, whereby lordship the learned court below proceeded expertly and the maintenance amount of rupees 8,000 was directed to pay to the petitioner, to the respondent, lordship. My only ground is that, lordship,
it was an expertly order.
expertly order, lordship. Lordship, I have a very limited submission to make, lordship. My only ground is that I have not received the notice. I am a resident of a different place. The respondent says that I am a resident of Umberman, Lalungaon, whereas I am a resident of Umberman. While passing the ex parte order, there was no satisfaction recorded by the learned magistrate that I was avoiding service willfully or I did not appear even after receiving the notice. And there was no satisfaction in the judgment also, paragraph 3 of the judgment. So, Lordship, and 8,000 was directed, 8,000 rupees was directed. I was directed to pay 8,000 per month. And from the date of the order, so I have a very limited period of setting aside this judgment, and I may be allowed to face trial, Lordship. If fixed time frame may be given, so that the right of the respondent does not get affected even. Lordship will find the interim judgment is at page 18 to 28. At paragraph 3 of the judgment, the learned court below recorded that per contra the second party never appeared before this court even after receiving notice and did not file written statement. Now, Lordship, this particular observation, as per 126(2), it says that when the magistrate is satisfied that the person is willfully avoiding service, only then the ex parte order can be passed. Here, there is no satisfaction recorded that the notice was served, properly served on the address mentioned, address of the petitioner, and when served, nothing is mentioned. Only it mentions that even after receiving notice. So therefore, Lordship, this ex parte order is bad in facts as well as in law, Lordship. And furthermore, Lordship, the quantum of maintenance, 8,000, Lordship, after this judgment was passed, Lordship, the respondent filed an application for enforcement of this order, and then DW was issued. In DW, a report came, if your Lordship, if your Lordship, here is this page 20 for a moment. Para number 11. The claim of the respondent is that the petitioner, whereas the second party has sufficient landed property wherein he engages in cultivation of broom, bamboo, etc., and also possesses a vehicle for public transport, hardware shop, and computer xerox shop, wherefrom he earns sufficient income. So this is the claim of the respondent that I have land for cultivation and I own a public transport vehicle. Since the DW was issued, may I please order of the court below, Lordship. On 10/8/23, an order was passed. As DW returned without execution. As per the report of DW, there is no movable property in the name of the opposite party. So, Lordship, the quantum of maintenance is also exorbitant. Lordship, in fact, I respectfully submit that the petitioner has to pay maintenance to his wife. And in fact, there is no denial to that. But Lordship, let there be a fair trial at least. Regarding the quantum of maintenance, 8,000 is too much exorbitant because I do not own a vehicle. I am just a laborer. And in fact, in my petition also I mentioned that I purchased a vehicle which was subsequently taken back by the finance company. Lordship, now I am in a position that I cannot pay anything. So, Lordship, I made a suggestion to my learned friend that can I pray that this ex parte order, since I do not want that the claim of the respondent, the right of the respondent gets affected. Since this ex parte order, Your Lordship may set aside this ex parte order and a direction may be made to the petitioner for an interim payment of a certain sum of amount so that she also gets something, Lordship. Can it be done, Lordship? And after that, we'll face the trial, Lordship.
Now, this application has been filed under 482. But on the last occasion, I made an objection to the maintainability of this petition. Because there is already a remedy under the code, under 126.2, that if you are aggrieved by an ex parte order, you should approach the same court by an application under 126.2. There are several judgments where it says that where the statutory remedy is already there, then the inherent power of this court, which is to be used in exceptional circumstances. Therefore, a 482 application for vacating an ex parte order in a maintenance case is not maintainable. My humble sir. Secondly, regarding the quantum of, whether he received notice or not, there is a specific finding at para 3 on page 18 that he received notice and he did not file written statement. That observation is based on record, Lordship, the LCR would reveal. Thirdly, regarding the quantum, Lordship, I was thinking 8,000, it seems it's something more, but I have just checked out the net. The minimum wages of India of an unskilled labor is 9,800, which roughly is 320 per day. Now, 8,000 per month is roughly a wage of 260 rupees. It's lower than a minimum wage of an unskilled labor. Now, Lordship, kindly see what are the exhibits given in the order. I have a daughter who is studying at school. I have to pay the school fees. We both have to also live, maintain our expenses, including food, clothing, and shelter. In my view, 8,000 is also not appropriate. It has to be more. But since there is already an order and I have accepted the order, I have gone for enforcement, I will not argue on that point. But Lordship, the quantum is after considering all the expenses, it's rightly given. And moreover, the petitioner is a driver who is considered as a skilled labor, whose as per the Government of India norms, it's 18,000. He earns around 600 rupees per month. Therefore, if he has son and a daughter, giving 260 rupees to his son and a daughter would not by anyhow be more than what is necessary. Firstly, Lordship, it is not maintainable. I place a judgment, and there is a limitation clause also. There is a judgment of this honorable court where if it is barred by limitation, he has also the occasion to file the condonation of delay, which is also maintainable. Therefore, he can very well approach the same court by 126(2) application by filing a condonation of delay. And secondly, the judgment is 2013 7 SCC 789. Lordship, Lordship, in this matter, the Honourable Court has held that when there is a specific remedy by way of appeal or revision, inherent power under Section 482 should not be resorted to. Paragraph, yes. Para 11, para 14. It starts from para 14. In our considered opinion, the complainant ought to have challenged the order before the Honour in revision under para 27, and not by invoking inherent High Court under 482. Maybe in order to circumvent the provisions of 397 and 40, and the complainant moved the High Court under 482. In the event a criminal revision had been filed against the order of Session Judge 319, the High Court, before passing the order, could have given notice of opportunity. So far as the inherent power of the High Court is concerned, the law in this regard is set at rest by this court by Catanab decision. However, we reiterate that when an order not interlocutory in nature can be assailed in High Court revision, then there should be a bar in invoking the inherent jurisdiction of the High Court. In other words, the inherent power can be exercised when there is no remedy provided in the code. Procedure for redressal of the grievance, para 28. It is well settled that the inherent power of the court can ordinarily be exercised when there is no express provision in the code under which order impugned can be challenged. That is the law. There is a specific provision for redress of his grievance. Therefore, there is this inherent power may not be exercised. That is my submission regarding maintainability, and regarding quantum. It is lesser than the minimum wage. Lordship, I have a daughter. If Lordship sees the exhibits, the school fees receipts are also exhibited. Therefore, appropriate remedy of the petitioner would be to move an 126(2) application along with a condemnation of delay. And if he is aggrieved by the quantum, he can very well come under 127. Deeply obliged.
Regarding maintainability, I have placed the judgment of 3 judges. The judgment which is placed by my learned friend is passed by 2 judges bench. This judgment, Prabhu Chawla, on earlier occasion, Lordship, I already made the submission on regarding maintainability. 482, Lordship, this judgment, Prabhu Chawla versus State of Rajasthan. Here, Lordship, Madhu Limaye was also discussed. If the Lordship peruses paragraph 5, starts from paragraph 5, page number 3. May I read, Lordship? Mr. P.K. Goswami, learned senior advocate for the appellant, supported the view taken by this court in the case of Dhariwal Tobacco Products Limited, Supra. And he pointed out that in paragraph 6 of the judgment, Justice S.B. Sinha took note of the several earlier judgments of this court, including that in R.P. Kapoor versus State of Punjab and Som Mittal versus State of Government of Karnataka, for coming to the conclusion that only because a revision petition is maintainable by the same by itself would not constitute a bar for entertaining an application under section 482 of the code. Mr. Goswami also placed strong reliance upon judgment of Krishna Iyer Justice in a division bench of the case of Raj Kapoor versus State of and others versus State and others, relying upon judgment of a bench of 3 judges in the case of Madhu Limaye versus State of Maharashtra, and quoting therefrom, Justice Krishna Iyer, in his imitable style, made the law crystal clear in paragraph 10, which runs as follows. The first question is as to whether the inherent power of the High Court under Section 482 stands repealed when the revisional power under Section 397 overlaps. The opening words of Section 482 contradict this contention because nothing of the Code, not even Section 397, can affect the amplitude of the inherent power preserved in so many terms by the language of Section 482. Even so, a general principle for which this branch of law when specific provision is made, easy resort to inherent power is not right except under compelling circumstances. Not that there is absence of jurisdiction, but that inherent power should be invade areas set apart from specific power under the same code. In Madhulimaya versus State of Maharashtra, this court has exhaustively and, if I may say with great respect, correctly discussed and delineated the law beyond mistake. While it is true that Section 482 is pervasive, it should not subvert legal interdicts written into the same code. Such, for instance, in Section 397(2), apparent conflict may arise in some situations between the two provisions, and a happy solution. Now here the solution is, Lordship. At the last page, Lordship, last paragraph, the answer is obvious that the bar will not operate to prevent the abuse of the process of the court or to secure the ends of justice. The level of the petition filed by an aggrieved party is immaterial. The High Court can examine the matter in an appropriate case under its inherent powers. The present case undoubtedly falls for exercise of the power of the High Court in accordance with Section 482 of the Code, even assuming although not accepting that invoking the revisional power of the High Court is impermissible. I am therefore clear in my mind that the inherent power is not rebuffed. In the case situation before us, counsel on both sides sensibly responding to our allergy for legalistics rightly agreed that the fanatical insistence on the formal filing of a copy of the under so and so. Our conclusion concurs with the concession of counsel. These are not relevant. In our considered opinion, paragraph 6, considered view, any attempt to explain the law further as regards the issue relating to inherent power of the High Court under Section 482 is unwarranted. We would simply reiterate that Section 482 begins with a non-obstante clause to state, nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise to secure the ends of justice. A fortiori, there can be no total ban on the exercise of such wholesome jurisdiction, where, in the words of Justice Krishna Iyer, abuse of process of the court or other extraordinary situation excites the court's jurisdiction. The limitation is self-restraint, nothing more. We venture to add further reason in support. Since Section 397 CRPC is attracted against all orders, this is not a country we would limit the ability to influence powers only to picking. This is not pretty important. Okay. So 482, Lordship, there is no bar, even though there is alternative remedy to secure ends of justice and to see whether there is an abuse of process of court. And if I may say, where is the abuse of process? The order dated, the ex parte order, ex parte judgment, Lordship. Ex parte order passed by the learned magistrate. The order nowhere says, Section 126(2) specifically says that magistrate can pass an order of, can decide on maintenance application ex parte only when he records the satisfaction that the person is willfully avoiding the service. Here, Lordship, at paragraph 3, there is no satisfaction. The satisfaction is inside the mind of the learned magistrate, but not in the judgment, Lordship. If I may say so, Lordship. Furthermore, Lordship, and why I am saying, submitting, Lordship, that I have not received the copy issued in MR case. They file a CR case also against me. There the address is different. This I have received after passing of this judgment. Here, in MR case, they stated my address as Umbormon Lalunggaon. In CR case, they stated my address as Umbormon. And in my petition, I have clearly stated that I am a resident of Umbormon. I am not a resident of Umbormon Lalunggaon. And where is the satisfaction, Lordship? In fact, if your Lordship peruses the LCR also, the postal receipt, receipt, if your lordship peruses the LCR also, lordship, the postal receipt also says my address is Ulukunchi. I am a resident of Umbarmon Lalungaon. And the postal delivery address here also says that at one point it says that insufficient address, and in the meantime someone corrected the address while the postal receipt, the postal article was with the postal department. Someone corrected it because the postal delivery receipt, if your lordship is the LCR, it will reflect, lordship, the postal delivery receipt. So how could the learned court below draw the satisfaction that I received the notice, lordship, in the judgment? This postal delivery receipt nowhere says that the item was delivered in my address. In fact, there is insufficient address, it also says in the middle of the postal delivery report, lordship. So based on this postal delivery status, which at one point of time says that insufficient address, and on 27/8/22 it says that item delivery confirmed, whether it reached my residence or not, this postal delivery report suggests nothing. And regarding the satisfaction that I was avoiding service, and I, even after receipt of notice, I willfully avoided service, where is that satisfaction, lordship, in the judgment? And furthermore, lordship, if I may respectfully submit,
I have a
lordship.
any other more.
My lord, I would like to talk to you.
The case relied upon by him supports me firstly, and it is an settled law. It was between whether revisional power and 482. Even in presence of the revisional power, the whether 482 would be maintainable or not, this is quite different, and that was a consented order, and it is not a binding precedent. That case shown was a consented, and it was against an interlocutory order. Now the question there was whether a 482 application would be maintainable if there is a possibility of a revision. Now this case also clearly reflects that if there is a statutory remedy under the code, this 482 would not be maintainable.
In fact, the day before yesterday, the petitioner was again arrested for non-payment of lordship maintenance, the order dated 22/11, because he cannot pay. Now he already spent 14 days last month in jail.
May I please your lordship? My lord, regarding item number 6, my lord, earlier I submitted the case diary not received, and your lordship has passed an adverse order against the IO. But right now, my lord, I came to know that item number 40 and 36 is the, my lord, same PS case, my lord. And in the morning, my lord, that item number 40 actually someone adjourned. So, my lord, that, my lord, case diary is tagged with item number 40. So, my lord, my prayer...
6.
Yeah, 36, my lord.
No. Adverse order was passed on
item number 36 against the IO, my lord, for not sending the case diary. But in fact, it is available with us. But it is tagged with item number 40 of today's list, my lord. Today somebody has mentioned item number 40, my lord. So I am not aware about that. So, my lord, this matter may also kindly be fixed with item number 40 on 14/5, my lord. So, my lord, item number 40 is already fixed on 14.
Item number 40. Item number 40 it was fixed.
No, your lordship.
No, item number 40 we received receipt.
36 and 40, my lord, same PS.
Same. Then 40 we have received.
Received. The case, right?
8, 9, 7.
Oh, your lordship, put the matter may kindly fix on 14/5 because 40 is already fixed on 14/5.
This one, 45. Later on,
May I please your lordship? So far item number 50 is concerned, if it can be taken on 17th, lordship, there is some urgency. Matter is fixed on 20 in the code below. Item number 50 of the daily list. It is in the order column, Lord. It can be kindly taken on 17th, Lord. 17th of this month. 17/5, Lord.
Item
Deeply obliged.
May please your lordship, item number 55, lordship, petition 14, lordship. So it is by order. So it is by order, lordship. On 15, lordship. 14.
No, lots of matters are already been 40, not 40. So 40 may not come.
15, lordship.
Maybe
15, lordship. 55. 55.
Yeah, I have a meeting in fact. This will definitely she will cooperate with you.